Greetings to anybody who may be watching on replay later or whatever, because the stream just started. But welcome to those who are coming in. We will see if this happens. This is a scheduled court appearance in the EWU versus Moscow. I think City of Moscow, or is it MPD? I'm trying to find the actual docket listing, and that's the problem we had. But we did have this scheduled on the calendar, and then Kathy's Indie Zone reminded me it was happening today, and Lana's covering it. So I figured there's a few of us who think this is happening. So we're gonna hold on here and see if the courtroom stream will come on here at. It is 9, right? Was it 9 or 9? Oh shit! Tell me it wasn't 9:30 for this. It's 9, right? I believe it's 9 a.m. Let me double check my calendar. I need to pull this off screen for just a moment. I think I had it listed for 9. Do we know for sure? Has anybody got confirmation? And is Lana Truth and Transparency doing this at the same time, or is she going to be a half hour later? That's the question. So, let's put this like that. It's a little bit bigger. Like I said, the problem I have is I haven't found the actual court docket listing anywhere. This has been scheduled for quite a while, and several of us had it on the calendar, and we haven't heard that it's canceled, but we also can't seem to get a confirmation it is happening. So, and I would hate to think that it's at 9:30. We're going to be here a really long time, but I think it starts at 9. Last time we did this, it was playing on Lana's channel, and I was still sitting here looking at this screen because I guess I had to hit play or the refresh button, which I'm going to hit the refresh button from time to time just to make sure that we haven't joined the feed. She's live now, meaning Lana is live, and I'm assuming that she doesn't have the broadcast going, right? Can you confirm that? So appreciate that, and welcome, by the way. Thank you for checking me out, even if she's live. I figured a lot of people want to see Lana's coverage of it, so I don't mean to compete with her, but I have my own takes on things. So I thought I'd do my take. And is she live now doing this exact feed? Is that what she's going to be doing? Or is she, like I said, I'd hate to think that she's got a different feed link, but this is the feed link that I had. Thank you, Cat Farm, for making this your first choice. I appreciate that very much. We've got a growing number of family who pick us first, so that's very, very cool. Helps out a lot. Same screen like you have. Sweet. I got something. Jules is also live. Nice. So there's a few of us who think this is going to happen. Yay. Let's hope that it does, because that would be really funny if nothing happens. I believe. So I wish Kathy was here, Kathy's Indie Zone, and maybe she will show up here shortly. But I believe this was the scheduled hearing that they had, because this was on my calendar, and I think it was a scheduled hearing that they had to follow up on EWU's request for for public records that the city of Moscow or Moscow Police Department had withheld information and too heavily redacted stuff. And so they took him to court. And Megan Marshall postponed and made them do some legwork, which I thought was a little bit bullshit. She already knew what they wanted. They had written it in letters twice. And she says, well, put together a list of what you want. Well, they already had that. So that annoyed the crap out of me. And really all they did was delayed until the new law came into effect. The Olivia Gonzalez law, whatever they called it, the one that said that people can't see crime scene photos in Idaho anymore. So that was one of the documents that EWU had asked for, was the crime scene photos, and they postponed just long enough for the new law to take effect, which then allowed them now to not have to show those. So that was the entire purpose for me, in my opinion, for the delay. So we'll see what happens this morning. Robin, if you would like to come up and join me, please do so. I don't think I need to send you the link, but if I do, let me know and I can put the link in backstage or here or whatever. I'll just put it in backstage just in case you want to do it and you need it. Hide that. All right, so the link's backstage if you'd like to join. Good morning, everybody. Good morning, Moscow. Anyways, that's like a that became a joke one night. My voice is a little bit raspier than normal. I've only been up for a very short period of time. Took a shower and jumped on camera. Yeah, I was going to ask how Robin was feeling as well. I was hoping she'll. Yeah, there she goes. She's joining, so we can maybe talk about that a little bit. And how are you feeling, Robin? Oh, she doesn't have her something hooked up, right?
I'm
Are
here.
you there? Are you there? Okay.
Yeah, I'm here. I just didn't feel like turning my camera on.
Oh, fair enough. How are you feeling?
Not as bad as I thought I would have.
Well, that's good.
Yeah, I really thought I would be I'm probably at a 7 out of 10, maybe 7.5. I don't know, but I thought I'd be at like a 9.
Nice.
Yeah, but I got all the claim stuff filed and all that crap. So
nice.
Hi, Catform. Hi, Jasmine. Who else we got? We got Falcon Crest, John T4.
Yeah, buddy. So I think this is supposed to be 9, and I guess it looks like Jules is streaming it and Lana's streaming it. So I'm pretty sure they wouldn't start streaming it now if it was 9:30. So we all apparently think it is happening here at 9. So hopefully that does happen. I will do my best, by the way, to keep my commentary to a minimum so that we can concentrate on every word that's said. Now, if there's an obvious lull and somebody's looking up something or whatever and there's quiet, then I'll talk over that. But I will try to do my best not to talk over the video and leave my commentary at the end. But you know how hard that is for me to not comment on some stuff. I might leave a bullshit comment every once in a while, but I will try not to do lengthy rants. I expect there's going to be some bullshit in this one. Oh, good probably. Morning, Moscow. Brett Payne here. He's going to get famous for the Good Morning Moscow.
Hi, Foxy Rose. Hi, Nene.
Welcome. We will see what's going down in the hood. Foxy's in the middle of an entire refrigerator cleaning. Oh, well, that's cool. At least you can put this on in the background. I don't think there's a lot to watch. So it's more of an audio kind of thing anyways.
Cleaning out the refrigerator is important.
By the way, Robin, I had on my calendar when I was at CrimeCon, one of the nephews of a couple of the guys that escaped from Alcatraz has written a book and has a big documentary coming out, which is supposed to come out tomorrow on Discovery Channel.
Oh.
And they intrigued me so much with the new information that they had that I was like, oh my God, I got to watch the Escape from Alcatraz new documentary, which is supposed to premiere tomorrow. However, it's not on the docket. It's nowhere on the TV programming. And when I checked with AI about it. They said, "Yep, all indications is it's supposed to be tomorrow, but it's not scheduled tomorrow, so they must have postponed and haven't announced it yet. So they don't expect it's going to be on tomorrow because it's not on the calendar, but it is the date that everybody said it was supposed to happen. So somewhere along the line, they postponed it and haven't told everybody what the new
and
date is
didn't
or
tell
something.
anyone.
Yeah. So
Yeah, that sounds really interesting. I didn't even know about that.
yeah, I'm excited about it. I think we're going to try to do a few more of these watch parties. Like we might be able to even watch that on a
I'd
watch
love to
party
do more watch
Discord.
parties.
Yeah. Yeah. And we're going to do, I think we're going to do I got to find some kind of Bigfoot thing to watch for the Beyond channel on Friday night. We're going to do that kind of a live thing, but we have to be careful. Like if we get it on YouTube, we can probably do it live. But if it's something like a paid TV channel, we'll probably have to do that on a Discord thing.
Yeah, well, one thing is always we'd have to do it in Discord. Would be Expedition Bigfoot.
Instead of Nene.
Like,
oh yeah, go ahead.
Oh, I was just gonna say they're like 7 seasons into that show, and it's fascinating.
Which one?
It's called Expedition Bigfoot.
Oh yeah, we could just watch an episode of those or something like that. But if it's 7 seasons, probably we had a lot of watching to do.
Oh yeah. But I'm sure we can find something for Friday night Bigfoot related.
Yeah. And then I saw that Dago had done a Bigfoot special. I thought that was weird timing. Like I was like, we just decided to do that. Like how did he already do that? But you can't keep ahead of Dago. Dago's always like a step ahead of us. Lee, do you want me to send them to you also? Send what? Did you listen to them, Robin? Oh, you have new songs? Cat Farm has new songs.
Yeah, she has the Bigfoot songs, and I was going to listen to them yesterday and start doing a sizzle reel.
Yeah.
For Friday, and then yesterday happened. But I will be working on that today because I'm laid up and I have time to do it. So
nice. Yeah. How did we get them? Could you put them in the music library so I can access them, or?
She sent them to me on Discord. I can send them over to you. I have them on the computer now.
Okay, or just save them to the common assets music folder where we have. And so I don't know if you know, but I created a common assets, then music, and then there's a Beyond and a Devil's Advocates thing, and then there's inside that there's an audio channel and a video channel because sometimes we have videos and sometimes we have audio. So if you bin it in there somewhere, I could get to it that way.
I'll throw it in the music.
Okay,
I'll throw it in for the Beyond.
Okay, sounds good. All right, what are we looking for time? We're looking at about 4 minutes till it goes. I would hope that the stream would start early, but let's hope the stream starts at all. If anybody, by the way, happens to be watching the other channels like Lana or Jules on another computer or whatever, please let me know if you see them start the stream and we don't have ours going, because that happened before where Lana's had her stream going and I was like, it's not working for me, and then I had to hit the play button to start it. Which is weird because it should just automatically start in the player. I shouldn't have to hit anything extra.
You would think.
I think we could give Cat Farm the link to the music folder so that she can put stuff there directly. So maybe we need to give her give her access to that, to the music library on both channels. Just
I didn't realize she didn't have access to it.
Yeah, we'll do that.
But you need to, Cat Farm. So we have all your excellent music in a central location.
Tired for Eternity is called a drug seeker? Huh. Oh, I didn't read the first one.
When you go to the ER, they think everyone's a drug seeker.
Oh God. You know what's funny? I had a doctor that was known as Dr. Feelgood. If you went to him and said you wanted something, he'd prescribe it to you. Lana wants it all. She wants to decimate the entire apple cart. Oh, apple cart. Yes. And start over. Yeah. course, we could all want things, and what's going to happen and what we want are often two different things.
You can't always get
Back to the
what
fridge. You will
want.
do what I say when I say back to the fridge. Right. I'm going to keep hitting refresh because you would think that they would start the feed a little early before the judge walks into the courtroom or see. Of course, this is all televised Zoom. I suppose the judge is just going to sit in one place. Well, last time it was all televised. It was, meaning everybody was in their own individual place. It wasn't in the courtroom, but
yeah. Welcome in
one time
1983, Tabby.
One time they forced me to sit in a bed for 12 hours, no pain meds. Day after getting cut or out of the admission and having my colon and rectum removed, I begged the doctor to help me and he walked away. Wow.
Bastard.
Man, we have a mess in our systems.
Yeah, women in pain in the U.S., especially if you're someone who has fibromyalgia, they a lot of times we're just kind of dismissed when it comes to pain. Like yesterday, they didn't offer me Tylenol till I had been there for like 5.5 hours.
Tylenol is should be just basic 101. You shouldn't even have to get it.
Yeah, I finally said to the nurse, I said, you could give me some Tylenol. Tylenol is safe, correct? And she's like, oh, yeah, sure. Let me have the doctor order. I'm like, duh.
Yeah, and then you probably paid like $75 for a Tylenol pill instead of,
Yeah, I should have just taken the ones I had in my purse and been done with it. But
right. All right, we're going to keep hitting the refresh. Look at that. They tease me. I hit the refresh button and the play button comes up, but I can't hit the play button.
Yeah. Come on, people.
We're doing it live.
Yeah.
All right. Hopefully, like I said, if anybody else checks any of the other YouTubers like Lana or Jules that are streaming this, if you can see that they've got their stream started, please let me know so I can find out why my stream's wrong. But somebody did confirm that Lana had the same screen up that I do, so we should be good. Morning.
Yep,
Juliet.
she has the same.
Or Julie Tyler. See, it could have been Juliet. She has the same one up. She has the same screen. Okay, and it's just this dead screen. Okay.
Yep.
I need some footies on, man. My feet are cold.
You're normally always hot.
I know.
What's going on there?
I don't know.
Yeah, Vicky's. I rarely take Tylenol, so I take it when I have to. Fortunately, my PCP, he does prescribe Tramadol for me when my fibromyalgia in the winter is really bad. So if I need to, I do have a little bit of that, but I only take, and I always cut the pill in half. Everything knocks me the hell out.
Well, Julie is a fine name. It doesn't have to be Juliet, but Juliet does sound like fancy. Oh, it's Juliet. Let's see. Come on, let's do this. Yesterday, I watched like 8 hours of Kathy from Kathy's Indie Zone. Oh my gosh, she's incredible. Wow, I didn't know. Wow, 8 hours. Holy crap. You guys have stamina.
No, 8 videos.
I thought you said 8 hours. Oh my God. I see reading comprehension. 8 videos.
Yeah, Kathy's videos are excellent. Her attention to detail.
We're live.
All right.
How come I don't have audio? We do have audio. Oh, I need to share the screen with audio. Hold on. Nobody's talking yet, though.
All right, we are going on the record then. This is EWU Media LLC versus the City of Moscow, the Moscow Police Department. This is cause number CV 2926162.
You have audio,
This morning, I have Ms. Kennedy appearing here on Zoom on behalf of the plaintiff in this matter. Ms. James is also present, appearing as EWU this morning. I have Mr. Jones and Ms. Brereton appearing here on Zoom on behalf of the defendants in this matter. Ms. Batista is also present here for the hearing today as well. In addition to that, I have Mr. James appearing on behalf of the intervenors, Karen Laramie and Stacy Chapin in this case. Excuse me, and James Chapin and Maisie Chapin. This is the time set in the matter for the petition. Court has reviewed a number of documents in anticipation of oral argument here today. In anticipation, the court has reviewed the original petition in this matter. Prior to the proceeding here today, the court did enter a decision regarding the city's initial response. In that matter, the court did note that it was denying the city's request to dismiss EWU's petition based upon a failure to register to do business in the state of Idaho. That decision was issued on July 2nd of 2026. Since that time, the city has filed a supplemental responsive brief, 3 different declarations in the matter. Declaration of Anthony Dollinger, declaration of Timothy Smallridge, and declaration of Lori Hopkins. And then EWU has filed a supplemental reply brief, and the court has reviewed that as well. Court also had reviewed initially, of course, the responsive briefing filed by Mr. James back on April 20th at that time. So first, Ms. Kennedy, any preliminary matters to take up before the court hears argument this morning?
I don't think so. Thank you, Your Honor.
Mr. Jones, any preliminary matters to take up?
No, Your Honor, we're prepared for argument.
Right. And Mr. James, any preliminary matters to take up?
No, thank you, Your Honor.
All right. I guess initially with that information, my one request or preliminary matter is that the city did file a respondent's request and records log. Subsequent to that, Ms. Kennedy, on behalf of EWU, filed in her reply a table of records at issue. The records at issue that were filed by Ms. Kennedy appears to be, I guess, less than what was included in the respondent's request and records log. And I'm specifically looking at the last EWU request, which was August 28th of 2025, and which was denied or responded to, excuse me, by the city on September 15th of 2025. So Ms. Kennedy, I guess on behalf of the plaintiffs, are you essentially conceding or saying that the only records at issue are those that are listed in your reply, or are there still some records that EWU had initially indicated in its August 28, 2025 request that have not been received that you still wish the court to address in its overall decision?
Your Honor, I think we can safely say that what's in Appendix A and B is what we're requesting the court to rule on. There are some documents that the city put in their log and that were in the August 28th, 2025 request that may or may not have payment issues related to them. And so I think those are things that if it's just a matter of EWU making payment for those items, I think that Zach and I can work that out. And we can work that out with the city, but we just want to make it simple for the court. And so, yes, you can look at the Appendix A and Appendix B, and those are the records that we would like the court to rule on.
All right, thank you. Mr. Jones, are you in agreement with that at this point?
Your Honor, I'm fine with that. It does kind of, I guess I was going to, and I will include in my oral argument that up until this point, we really didn't know what was being requested, and it hasn't been narrowed down to this small amount until the eve of the hearing. And so part of our argument is going to be that we weren't sure what exactly was being requested, and that is a significant part of why we kind of got to where we are. And so I'll incorporate that into my argument. But with respect to the fact that this is all they're requesting, I mean, I guess I'm fine with the court narrowing it to just that, as long as we can incorporate that other aspect of our argument.
Okay. All right, thank you. Mr. James, anything to add on that?
All I would add, Your Honor, is I am pleased that petitioner did narrow it down. This is very helpful, and I think it helped to move the process forward.
All right, thank you. All right, with that then, Ms. Kennedy, I will start with you and you can present argument at this time.
Thank you, Your Honor. This case is one of the most significant criminal investigations in Idaho history, and Moscow led the investigation with assistance from other agencies. Now, these other agencies may have produced certain investigatory records, but these records were undisputably used, retained, and compiled by Moscow, and they became Idaho public records. So they must be disclosed unless an exemption applies, and Moscow simply hasn't proven an exemption. They have raised essentially 3 exemptions, which is custodianship, foreign law, and privacy, and I would like to go through each of those exemptions in turn. The first exemption that they've raised is custodianship, but the word custodian in the statute is not an exemption unto itself. And the Idaho Conservation League case, which we cited in our briefing, explains that the identification of the proper custodian has no bearing on whether the public records are exempt from disclosure. The legislature didn't intend custodian to be its own exemption. Custodian is simply the person within the agency who has certain administrative responsibilities for the records. But even if we interpret custodian as its own exemption, the city certainly had custody and control over these documents and is their custodian. They don't dispute that they have custody of the documents, which I think we can agree upon is some kind of physical possession. But they dispute that they have control. And the dictionary defines control as to exercise restraining or directing influence over or to have power over. And they certainly had control over these records. They requested assistance from other agencies. So they essentially requested that these records be created to begin with. These records were then provided by these assisting agencies, the FBI, Pennsylvania State Police, etc. And those were provided to Moscow to assist it in its investigation. Moscow has stated in its declarations that it was the lead agency for handling physical evidence. And that evidence went into their files, into their evidence log. This information was compiled into their files. And our statute related to investigatory records is quite broad, and it defines those records as anything compiled into the agency's files for law enforcement purposes. And these records were used and retained by Moscow, which makes them public records. And presumably these records were given to the prosecution to prosecute this case, which presumably would give them to the defense. And we can assume that some of these records, or maybe all of them, were part of the probable cause to arrest and prosecute Kohberger. So they underlie Moscow's activities as a law enforcement agency and as a governmental agency of Idaho. So they controlled these records. And every record, or I think most records mentioned in Appendix A, are referenced in a publicly available police report. And that's what that SUP number means, is that refers to the police report in which the document appears. And so all these documents were used in some way by Moscow Police Department. And so because of that, we believe that they were therefore controlled by Moscow. And these documents are a major part of the Idaho criminal investigation. If, for example, you take the Koberger interrogation video, that is a clear Idaho record. Brett Payne from Moscow PD flew to Pennsylvania along with a member of the FBI to interrogate Koberger in Pennsylvania. My understanding is that that was recorded by Pennsylvania law enforcement at their facility, but merely because it was recorded in Pennsylvania, in a Pennsylvania facility, doesn't somehow transform that into a Pennsylvania and not an Idaho investigatory record, particularly when Idaho law enforcement is there taking part in the interrogation. And so these records, this is a key Idaho record, and many of these other records that we are seeking are key parts of the Idaho investigation. And it would be poor public policy to say that these key criminal investigatory records that were requested to be created by Moscow, used by Moscow in their investigation and prosecution, were then exempt from disclosure to the public merely because they originated with one of these assisting agencies. The public has a right to know about how law enforcement conducted this investigation, and failure to disclose this information just invites unfounded speculation into this case. And so we believe that these documents should be disclosed because Moscow is the custodian and it has custody and control of these records. So the next exemption that's been raised.
I'm just gonna interrupt you there for just a minute, kind of taking the pieces in part here. So in reviewing your briefing, but hearing your argument today, are you saying that, taking, for example, the example you provided about the interview. So is it EWU's position that if Moscow or some law enforcement part of Moscow, whether it be the city of Moscow or any agency related to Moscow, if they helped in any way in assisting or took part in creating the record, then those are the ones in which they should be able to disclose? Or are you also extending that to, for example, taking your example of a Koberger investigation, if that exists, I don't know, but taking your word for that, if it was just Pennsylvania law enforcement and the FBI who interrogated him, Corporal Payne was not there at all, but yet that record is in the possession of Moscow because it was shared with them, is it EWU's position that they still must then disclose that, even though it was created and the Moscow had no part in creating that?
Yes, and I think that's because the Idaho Public Records Act is very broad. It says that public records are anything used or retained by the city, and the investigatory records exemption is arguably even broader, and it says investigatory records are those compiled in an agency's records, law enforcement records, just to summarize it. And so if it's that broad, that suggests that information compiled by law enforcement, regardless of who created it, becomes an Idaho public record, and it's subject to disclosure unless there's a particular exemption under the statute. So even if it was an FBI video, an FBI interrogation, so long as Moscow is using it, retaining it, compiling it into their records, it is an Idaho public record that's subject to disclosure. My example for the Koberger interrogation video was merely to just show how absurd this seems to me, that this was actually an interrogation that appears to be conducted by Moscow, but because it happened in another state, or it might have been filmed by Pennsylvania, that that the public does not get to see it.
Right. Thank you, Ms. Kennedy. And then I'm going to follow up with a question that I think you're probably going to address in this next part, but with regard to the next exemption concerning other law and how it may apply, whether it be federal or other state law. And my question is this, is that if EWU were to go to Pennsylvania to get the Pennsylvania record, and Pennsylvania law is more restrictive than Idaho, but an agency here in Idaho happens to have that record through that law enforcement sharing process, then my understanding it would be EWU's argument that they should be able to come to Idaho, even though they were rejected in Pennsylvania to get that record that was created by Pennsylvania. They should still be able to come to Idaho.
That's exactly right.
And can you talk about, if any, a chilling effect that might have upon law enforcement agencies in being able to share records and investigations like this?
I think that's possible. But we have a policy in the state of Idaho that records are subject to disclosure unless there's a statutory exemption out there that expressly exempts the document from disclosure. Pennsylvania, they have a different public policy, apparently. They keep a lot more things private or confidential. Idaho favors disclosure. Now, Pennsylvania could, I kind of doubt that law enforcement says, well, I wonder if I'm going to not help Idaho or not give Idaho information because the public of Idaho might see this. And that seems to me that would be unlikely, that Pennsylvania law enforcement isn't going to assist because somebody in Idaho might later get the record. I suppose that could happen in certain scenarios. But our legislature has made the decision that we're going to favor disclosure of records. And the legislature, maybe the court decides that we get the Pennsylvania records and the FBI records, and later the Idaho legislature could say, well, we need to do something about this and create an exemption for records received from outside agencies. But they haven't done that yet. They've decided the public policy of the state is going to favor disclosure. So I see that as a legislative problem and not a problem for the court. I don't think the court can create an exemption that's not there to serve a public policy. And I think it's a speculative public policy because it doesn't seem to me to be logical that law enforcement from another state wouldn't help, because several years down the road when the case is done, a record might get out. If anything, the law enforcement, I think, that was involved in this case should be proud of their work and should want the public to see what was done here and how the investigation was conducted, because it was, to me, as an outside observer, there was, this was ultimately a successful prosecution. And so the public should be able to see those materials.
I think you may continue.
Thank you, Your Honor. And so the next exemption then would be foreign law, and that's state and federal. And state law appears in Idaho Code 74-1041A. And when we look at exemptions under the Idaho Public Records Act, as the court is aware, we narrowly construe any exemptions, and that includes the meaning of the word state. And so, as we've argued in our briefing, state law means Idaho. It means things like the attorney-client privilege. There are other areas of state law that exempt certain documents. And so state law doesn't mean the law of any other state. It means the law of Idaho. And really, if we interpret state law to mean any state's laws, that's really an absurd reading of the statute, that somehow Pennsylvania or Washington law would apply to Idaho agencies and Idaho records. But even if we can interpret state to mean any state's records, the Pennsylvania and the Washington laws that have been cited only apply by their terms to their own agencies. They don't apply to Idaho or outside states in making public records determinations. Similarly with federal law, the city's most recent brief was the first time we actually understood what federal law they were claiming an exemption under, and that turned out to be FOIA. But there's a Idaho case that's directly contrary to that position, and that's Magic Valley, which we cited in our briefing. And that case states that the FOIA only governs the disclosure of public information by authorities of the government of the United States. It doesn't purport to govern disclosure of information by state agencies. And so that's exactly the argument that the city is making here, that FOIA somehow governs Moscow and governs the state agencies, but Magic Valley dispenses with that and says FOIA only applies to certain authorities of the United States. There are federal laws, for example, HIPAA and FERPA, that apply directly to states. So for example, if I went and tried to get information about a patient from a state hospital, or I tried to get educational records from U of I would get an objection under HIPAA or FERPA for sure, because those exemptions actually apply to the state and local agencies. But FOIA is different. FOIA doesn't work that way. It only applies to the government of the United States. And so a federal law, or at least the particular federal law cited here, does not exempt these documents. So moving into the third exemption that they've raised, which is privacy. And we cited the Wade v. Taylor and the Hymas cases. And those cases say that there's no categorical exemption for investigatory records. The city has to show for each record that there's a reasonable probability of harm. So here they would have to show for each record that there's a reasonable probability of an unwarranted invasion of personal privacy. And we just haven't seen that here. They need to produce some kind of evidence of that, and they haven't done so. And we provided, as I mentioned earlier, Appendix A, which lists the records that have not been disclosed to EWU. I don't know if the city is claiming a privacy exemption of some sort over those records, but we have not seen that to date. So assuming that they're not claiming a privacy exemption over those records, and we're just really talking about Appendix B, which is the body cam footage, they have asserted a privacy interest over those records, but the scope of that privacy interest has already been decided by the court in the permanent injunction. For example, there are witness interviews that have been blurred, and we understand that the court has already decided that those should not be blurred. The bedrooms are probably overly redacted, and we don't want to tread upon the victims and their families' privacy in that regard, but the court's order was narrowed to the death scene and the surrounding area, is my understanding of the order. And the bedrooms appear to be overly redacted. There are more bedrooms redacted than there are victims, so to me that suggests there's over redactions there as well. So we've requested for those records that the court conduct an in-camera review and order certain redactions to be removed as necessary. And I would also like to mention that the city's briefing focuses, well, they've focused on EWU's business model at several different times in the course of this litigation. But EWU's business model is really irrelevant. In Wade v. Taylor and in other cases, the court has made clear that the requester's motivation is really irrelevant for requesting the records, and agencies aren't supposed to discriminate based on who the requester is. And so any sort of reference to EWU's business model is just irrelevant to this case. So with that being said, none of the exemptions that they've raised, custodianship, foreign law, or privacy apply. And so these records must be disclosed because no exemption has been proven. And in my briefing, I also did mention attorney fees, because there wasn't, to me, clarity in the statute in terms of when we request those. So I can argue that now, or I can wait later, depending on the court's preference. But unless you would like to argue the attorney fees portion, I don't have any further comments for today.
Thank you, Ms. Kennedy. You can go ahead and argue that now, just so we have it, and then I'll hear from Mr. Jones.
Okay. We did request attorney fees under 2 separate provisions. I believe it was 74-124 and then 74-116. And 74-116 is kind of the typical attorney fees provision for public records requests, and it mentions frivolousness. But we did also cite Idaho Code 74-124, which that's the investigatory records exemption, which has its own fee provision. And it doesn't require a showing of frivolousness, it just requires the court's discretion to award fees. But we listed a number of reasons why we believe an award of fees would be appropriate in our briefing. So the court can reference those, but I think something that stands out to me today is that every argument that the city has made related to an exemption is contrary to established authority in some way. The custodian exemption that was raised is against the Idaho Conservation League case. The foreign law argument that was made is against the Magic Valley case. The privacy argument that was made is against the permanent injunction. And of course, you can make arguments that are, for reversing authority or for changing prior authority. But there was no argument made about why these cases or the court's prior order was wrong or was subject to challenge. The city just sort of argued these things anew. And so because of that, in addition to the other issues we've listed in our briefing, we believe an award of attorney fees and costs would be appropriate. So to overall summarize, what we're requesting is disclosure of the documents in Appendix A, an in-camera review and removal of redactions consistent with the permanent injunction, which would be Appendix B, and then our fees and costs. But thank you, Your Honor.
Thank you, Ms. Kennedy. Mr. Jones, response?
Thank you, Your Honor. To begin with, Idaho Code 74-102 sub 4 requires that the requests have enough specificity to allow the public agency to determine what the records are and what the records being sought are. It does not require the public agency to engage in any sort of investigation regarding what exactly the petitioner is requesting. And in Wade v. Taylor, which is cited by the petitioner and for other reasons, the main holding in that case is actually that the records that are being reviewed by the court are reviewed at the time of the request, not at the time of the hearing. And that's kind of what we have right now, where we have a much narrower review of the records that are being requested, whereas what the city's been really kind of having to work through is the information that was attached to the declaration of Amy James on March 30th to determine what exactly the records that the petitioner was requesting. And so until the Appendix A came, which is respectfully just too late, the city really didn't know what records the petitioner was requesting, and they lacked specificity, they were ambiguous, and they couldn't be met with reasonable effort.
So Mr. Jones, I do want to ask though, in the respondents in the city's request and records log, and that's, if we look at the time of the request before this litigation was initiated, so August 25th of 2025 was the last request after it had gone through some revisions with the city's responses, and the city responded to that. In that request, the EWU, for example, put a request of in the supplement. So the city has previously provided on the website access to the public to a bunch of information, to include the police reports. EWU put on there supplemental 42, which directs you to that supplemental. The surviving roommate's first interviews dated 11/13 of 2022. And the city's response was the city was unable to identify a specific responsive record without additional information from EWU, and actually requested the officer's name and or the initials of the individual, amongst other things. And when you open up that supplemental 42, I guess I'm wondering, how was it difficult for the city to identify the specific responsive record to that?
I think that the answer to that, Your Honor, is just that without listing the names, the location, the time of the records requested, the city can't just go through the 58 terabytes of information that are that the city has relevant to this investigation. And so this without specificity, this isn't a discovery proceeding. And the city needs that specificity to determine what exactly is being requested, i.e. names of the officers, location, times, etc.
I guess I'm wondering, because I think if I recall, if you pull up that supplement off the webpage, it's 4 or 5 pages, and then it is an interview with 3 different people. So I guess I'm on top of that, Mr. Jones, I'm wondering, the city provided declarations. Clearly, there's a lot of information in this case. No one is disputing that. But there's also, it looks like, there's been a situation where the city, I think the language was essentially that other agencies or have often just provided information or dumped the information without it being really categorized, or so it makes, in some way, the readings of those declarations make the court question at this point whether it has been categorized, whether the city even knows all of the information that it does have, which then would make it, understanding the burden is on the requester, which is EWU, but wouldn't it make it very challenging for a requester to request information if the city doesn't know what it actually has, because there's so much information? Do you see
Yes, I certainly see Your Honor's point. I don't think that if this were a discovery proceeding, we would be having a different conversation, but this is a Public Records Act proceeding. And so the onus is really on the requester to specifically request the information that it's seeking. And if the requester doesn't know what information it's seeking, and it just wants a broad category of information, that's not an appropriate request. That would be an appropriate discovery request. But it can't just request all surveillance footage and expect the city to go outside the 4 corners of the request and try to determine what exactly the petitioner is seeking. And so there is a little bit of this is an unusual situation. In most public records requests and most public records situations, this wouldn't occur. But given the volume of information in this case, the city can't just spend all the time searching for unspecified information.
And I appreciate that, understand that. I guess I'm just a little troubled by some of the, again, in the records request or records log, you have 2I, EWU requested from supplemental 271, which is provided on the city's website. They've narrowed it down to an interview with initials KD, dated April 12th of 2024, and an audio CD, item 876, as specifically referenced, but the city saying we're unable to identify a specific responsive record without additional information. I guess the question is for purposes of the statute, I think the language is pretty clear as far as them providing the specificity to allow the agency to reasonably go about finding the document. And so I guess I'm wondering if how how more specific does a person need to be, or an individual or an entity need to be in requesting? And what is the consideration of the reasonableness? Now, I understand in this case, does the court take into consideration also reasonableness in the sense of the amount of individuals who've been working on for the city who've been working on this? There being, as I understand it, 2 full-time people, the clerk and the records custodian, or the individual, Mr. Smallridge, working at evidence custodian, primarily being the ones who are trying to find or locate or provide or produce this information. But I suppose my question is that does that or should that stand in the way of the city being able to provide it?
I guess I'm not quite sure exactly what Your Honor's asking. I'll just sort of summarize it as there is a litany of requests here. Appendix A has really, really narrowed that request, but we haven't been reviewing Appendix A. We've been reviewing the declarations and the petition that make us we really have to squint at those to determine what is being requested. And even that is taking a lot of effort, and I would submit that it's more than reasonable effort to determine what is being requested. And the question of when is at the time of the request, not at the time of the hearing after we've sort of nailed down some of this information. And so the city has not been able to respond to the requests generally with reasonable effort because of the lack of specificity in the requests, again, on August 18th at the time of the request.
All right. Thank you, Mr. Jones. And then I guess to follow up on my initial question from the beginning of the hearing then, based upon this argument, would the city be asking the court to kind of disregard Appendix A, but go off of what was requested, which is from the, as I understand it, would be the August 28, 2025 request, make its decision based upon that?
So I think legally the court is obliged to make its decision based on the August 18th, 2025 request. From a practical standpoint, we appreciate that it's narrowed down, but that's not what was briefed, that's not what was prepared, that's not what was argued up until last Friday. And so, had the petitioner presented that information, frankly, prior to filing his petition or any time during the pendency of this case, rather than less than a week before the hearing, we may have had a different conversation with the petitioner, and we may be having a different conversation today. But I do think, to answer your question, I appreciate the practical nature of just responding to what's being requested, but legally, we're looking at the August 18th request.
Right. Thank you for the clarification. You may continue your argument.
Thank you. I'll move on to the question of unwarranted invasion of privacy. Idaho Code 74-124-1C provides an exemption from disclosure for materials that are an unwarranted invasion of privacy, and that's defined in 74-101-17A. There is not a lot of Idaho case law determining what an unwarranted invasion of privacy is, which is why the city pointed to federal case law. And the city reasonably relied on that federal case law based on guidance, frankly, from this court in Laramie, which also relied on federal case law to determine what an unwarranted invasion of privacy is. And I just say that to address sort of the attorney's fees argument later on down the road. In any event, the petitioner submits that this decision has been made in the Laramie case as res judicata, and that res judicata applies to what is an unwarranted invasion of privacy. And that's not exactly applicable here because the Laramie case focused on a couple of specific named litigants. And in fact, the petitioner objected to the standing of the interveners to discuss anything outside of those specific named litigants. They didn't object to the standing of the city to address those matters. And so the Laramie case was actually a very narrow decision. And one of the takeaways from the Laramie case is that once this information is disclosed, we can't get that back. And so should the court find that there is an unwarranted invasion of privacy and that all of these surviving roommates, surviving family members that weren't litigants in the Laramie case, not to mention anybody that was caught up in the scope of the investigation who disclosed numerous private details, including, their addresses, their names, their whereabouts on this day, all sorts of private information. They have an unwarranted an interest in their own privacy as well. So we point to the federal cases because the federal cases, there's a fair bit of case law examining what this is, and there's also a balancing test. And that's why, similarly with the balancing test, that's why we point to what the petitioner's motives are, because it's relevant to the balancing test and is relevant to the privacy interests of the individuals who are not litigants in the Laramie case. And we submit that the balancing tests rests in favor of the of protecting the privacy interests of the individuals who participated in this investigation. And again, Chief Dallinger's declaration goes into the nature and the wide net that was provided of information that was provided in this. And it's our position that those privacy interests are paramount in this specific case relative to the interests of the petitioner. With respect to the custodian of records argument, Your Honor, Idaho Code 74-103-1, it provides that only the custodian of records needs to respond to a public records request. And then it defines custodian of records as the person with custody and control of the records. It's our position that the city doesn't have control of the records, and the agencies that created the records are the ones that have control of these records. And I outlined in our brief as to why that is. But significantly, the city didn't, it's the prosecution that used these records. It's the prosecution, which is not the city, that was compiling these records for the purposes of prosecuting Mr. Koberger. And the city was just working with the other agencies in compiling the records. And to use the example of the city police officer going to Pennsylvania to conduct an investigation, the records that were created by the Pennsylvania police are Pennsylvania records. The records that were created by the FBI are FBI records. Any police reports, if the Idaho City of Moscow officer had a body camera and he created those during that investigation, those would be Idaho records. But essentially what the petitioner is doing here is abrogating both state and federal law for the out-of-state agencies by simply requesting these records in Idaho. And it's our position that that's precluded because, one, the city is not the custodian of these records. They don't have control over these records in the way that is contemplated, but also because Idaho Code 74-104-1A provides that records are exempt from any federal or state law, if they're exempt by any federal or state law. And of course, nobody's arguing that federal law is not explicitly worded in that statute, but we're certainly arguing that state law says what it means, what it says, which is simply state law. And of course, I point out that later on in that same statute, it provides the Idaho Supreme Court. It doesn't just say the Supreme Court. And so I think that distinction there is telling. The federal records, the federal law does apply. The Pennsylvania and Washington state law also does apply because of 74-104-1A. And the petitioner provides a little bit of a chicken or the egg argument in the sense that they argue that for example, the right to know law out of Pennsylvania only applies to Pennsylvania. Well, we are talking about Pennsylvania records here. And so because these are Pennsylvania records that were generated in Pennsylvania that are governed by Pennsylvania laws, the court should consider that not because of the Pennsylvania laws, but because the Idaho Code contemplated that. And similarly with the FOIA argument, these records are probably not disclosable under FOIA with the exemption 7, exemption 5, et cetera, the ones that are listed in the brief, the Privacy Act. And because the Idaho Code contemplated federal exclusions, including FOIA, the FOIA applies. Now, the petitioner points to Magic Valley to hold that FOIA doesn't apply, but that's not exactly what the Magic Valley case says. The Magic Valley case specifically focuses on the question of whether or not names are personnel records, and it's specific, and it's narrow to that question. And the Magic Valley case holds that had the Supreme Court, or sorry, the Idaho legislature choose to include names as personnel records, they would have done so specifically in the personnel records exemption, which is not what we're discussing here. So it's our position that the Magic Valley case is inapplicable to this argument. Moving on to the fees question, in the brief, essentially the petitioner is saying, well, we'll pay the fees. Well, this brings us back to the top where we don't know what the petitioner is requesting. And so we're having to anticipate essentially what's being requested in this briefing. And it's our position that Idaho Code 74-102 provides that it's appropriate for the city to require fees in order for to respond to the requests. And on the eve of the oral argument, the petitioner says, "Oh well, we'll pay the fees." I mean, that could have been and should have been done at the time of the petition or at the time of the request. So the refusing to disclose that information because the fees at the time of the refusal of the withholding of that information is appropriate, and it just kind of brings us back to the top that until the Appendix A was provided, the city really had no clear idea of what was being requested. Finally, regarding attorney's fees, we would just simply submit that this was not, that attorney's fees aren't appropriate under either statute. The city's not trying to obstruct justice. The city's not trying to inappropriately withhold information. The city's trying to protect investigative processes of law enforcement. The city's trying to protect privacy interests of persons that aren't parties to this litigation. The city's trying to make sure it doesn't err on the side of providing information that can't be brought back that probably should have been withheld. And so the city's not obstructing anything, really. We're trying to comply with the code. And frankly, this is just one of those cases that needs judicial guardrails, no matter how the court decides. And so with that, Your Honor, I'll submit.
Thank you, Mr. Jones. Mr. James?
Thank you, Your Honor. Leander James on behalf of Karen, interveners, Karen Laramie, Stacy Chapin, James Chapin, and Maisie Chapin. You know, ever since, Your Honor, ever since the court entered its judgment granting in part the permanent injunction in the case of Chapin v. et al. v. City of Moscow, LATOC case number CV 29250755, I felt like kind of like the little Dutch boy with his finger in the dike, trying to reasonably and under the statute prevent dissemination of information that is harmful to my clients. I think the issues were very well briefed. The court will note I didn't write a supplemental brief because I felt the court had sufficient information. And I also had been in contact with Mr. Jones and with Ms. Kennedy at some point along the way. So I was aware of what they were going to say, but I do have some additional comments here that maybe will add something meaningful. First, the impact of the release of information on privacy rights. Petitioner argues correctly that EWU's business model is irrelevant to the case. And I say correctly insofar as you look at it from the point of view of the court under Idaho's FOIA, Idaho Code 74-101 at sequence, is not to consider what the information is going to be used for. However, that logic does not carry forward when the court is to analyze the unwarranted invasion of personal privacy. And here's what I'm saying. I appreciate the court under the FOIA may not consider what the requester intends to use the information for. However, the court and the city are duty bound under the statute to determine whether that information being disseminated will result in unwarranted invasion of personal privacy. And the court has already seen in the prior case, the Chapin et al. Case, that the use of this information results in severe and permanent detrimental impacts to my clients and likely others. And that can be considered by the court. So to give sort of a raw example, I understand that not this court, but another court released autopsy records. I think they were already out there. And somebody used those with AI to try to generate images, gruesome images. And what I'm saying is the court should consider, and the city should consider, how this information out there will impact the unwarranted invasion of personal privacy. With that, I'll move to the new snag. It's a new snag here, I think, that has not been addressed. On July 27, 2026, and by the way, I would have briefed this, but it just happened. On July 27, 2026, in Ada County, case number CV 012615-094, and pursuant to Idaho Code section 19-4901 through 19-4911, the convicted murderer, Mr. Koberger, filed for post-conviction relief. It's imperative that that case proceed uninfluenced by the public disclosure of information. This is an entirely separate analysis, but it impacts, I think, what we're doing here today. In the underlying criminal case, this court and the court of the Honorable Judge Hippler previously entered non-dissemination orders based upon the court's inherent authority to manage criminal proceedings and protect the defendant's constitutional rights to a fair trial. This court's ruling was later affirmed in Associated Press v. 2nd Judicial District of the State of Idaho, County of Latah, 172 Idaho 113, 2023 case. And the court stated, and I'll quote here because I think it's very relevant to frankly both analyses. The Supreme Court said, quote, "We recognize that our trial courts have an increasingly difficult task in balancing the Sixth Amendment rights of a defendant with the First Amendment protections afforded the press. With the advent of the internet and social media, the balancing act has become even more challenging today than it was in the 1960s and 70s, when Shepard and Calder were decided. Although these are well-guarded rights, those seeking to enforce them must still bow to the jurisdictional rules and procedural channels litigants are constrained to follow," unquote. And that's at Associated Press at page 124. The same logic is now triggered here. In his post-conviction relief case, Mr. Koberger and his court-appointed attorney, which he now has, will likely argue that new information has been dug up, by online sleuths, conspiracy buff, and others that are using this information that is being disclosed to then contact potential witnesses to, in fact, in some cases, harass the witnesses to find information out that they can then use to their economic advantage through blogging and so forth online. This is a new cycle. This is why, and I do belabor this a little bit because I think it's really critical. This is a new era we're in. And it's really unprecedented. We're dealing with something that this court has already set a precedent. I think that has rippled through, I know, other states, including Nevada. And the difficulty here is, and the tension between the Sixth Amendment and the First Amendment, are that this information gets disseminated, then it's thrown wide and far. So-called real crime sleuths and investigators and media then contact witnesses in the criminal case and influence these witnesses, and then they create conspiracy theories and so forth, and the court knows this in detail, I'm sure, that then turns around and can be used by the convicted murderer to then seek post-conviction relief. And I want to point out here, I'm not arguing Mr. Koberger's rights, but I am arguing the integrity of the system. I think what has to be considered is, as this information is let out, it will be used by the media in a way that can negatively impact the post-conviction relief process and the potential that it would be sent back for a new trial. And we've got a real mess on our hands because we've got just this deluge of information. The dam is broke and the information is out there, and it could very well corrupt the whole process that is still going on in the post-conviction relief process and the potential for a new trial. And looking at the appendices that petitioner provided, I see numerous references to witnesses and wanting unblurred faces and information about witnesses. Well, they're going to go contact these witnesses. And when you contact witnesses, you influence witnesses. And what then happens if the reality occurs that Mr. Koberger prevails in his post-conviction relief and is sent back for a new trial? For all the reasons the court entered a dissemination order in the underlying criminal case, all of those reasons are now present here to prevent further dissemination of anything, for that matter. And I know it's difficult and it's always hard to bring a new argument up an oral argument. And it just happened. It just happened. The timing was, I mean, I've been dealing myself with a deluge of media trying to get at my clients once the post-conviction relief was filed. I've been spending hours and days fending off media. I'll tell the court, as an officer of the court, it's been very difficult. And it's my honor to do so, but it's difficult work. I literally have to worry about media showing up at my client's door. So in sum, Your Honor, I believe under the FOIA analysis, the court and Moscow, the city of Moscow, are duty bound to protect the privacy rights of not only my clients, but the witnesses and all involved. However, I submit that it's an entirely new analysis now that we have the post-conviction relief case pending that warrants a non-dissemination order equivalent to what the court previously did in an underlying criminal case until that process plays itself out. Thank you, Your Honor.
Thank you, Mr. James. I'm going to just switch back to Mr. Jones to see Mr. Jones before I hear lastly from Ms. Kennedy as a reply. But Mr. Jones, given what Mr. James has brought up here, do you, no obligation here, but do you wish to add anything further on your argument at this point in time?
Only that we would join in Mr. James's arguments related to the petition for post-conviction relief.
All right. Thank you, Mr. Jones. All right, Ms. Kennedy, reply.
Thank you, Your Honor. I just have 2 points I'd like to address in reply. The first is on the broadness or the narrowness of the request, however you want to see it. But Idaho Code 74-1029 does allow for the parties to have a dialogue about what records are being requested and to get more information about those records and to narrow the request. And that's exactly what happened here. And by the time they got to the August 28th request and the September 15th denial, it was very clear what records were at issue and what records were available and what had been denied by the city and why. And when we originally filed this case, it was very clear that the denials were based on custodianship, foreign law, and privacy. And so regardless of what documents were or weren't at issue, the exemptions that we were dealing with were very clear. The city made that very clear in their denials. And so I don't think that the city can say that we were prejudiced or we didn't understand what the issues were. Even if the particular documents at issue were fuzzy, we were very clear by the time of filing what the exemptions at issue were. But again, the statute does allow the parties to have a dialogue and then to come to a resolution. And if you look at the September 15th denial, it's very clear what EWU was requesting and what the city was denying and why. And then my second point related to the post-conviction relief. I mean, I'm coming into this a little bit cold. I have not seen any briefing on this issue. And so I would object to the court considering that when we haven't had a chance to research or brief any of those issues. But I think we have to go back to the statute and the case law. Wade v. Taylor says that the justification for the denial is assessed at the time of the denial. We didn't have this post-conviction issue at the time of the denial. That wasn't out there. But importantly, in Wade v. Taylor, there's no categorical denial of investigatory records. You don't get to just say, well, the case is open again, therefore you get nothing. The city has to show a reasonable probability of harm for every single record. And at this point, they've already released a lot of records in this case, and we can't pull back all of the records that have already been released. And so they would have to show, the city and the interveners would have to show that, well, for each of these records in Appendix A, that there's a reasonable probability of harm. And I suppose the harm that they're raising is fair trial. So they would have to show, well, you can't have that record because it might prejudice the right to a fair trial. But we have to also look at reasonable probability of harm. Is there a reasonable probability that the petition would be granted such that there would be a trial? And so I think the court would have to look at that. And the interveners, I don't believe, have standing to protect the defendant's right to a fair trial. I think that would be something that the city or the defense team would have to. So with those two issues, unless the court has questions, those are my comments on reply. Thank you.
No further questions. Thank you. I appreciate counsel, your briefing in this regard, and also providing the records logs provided by the city and the most recent addendum. That just helps for the court clarify, given the volume of records that clearly was cited to in the declarations and the amount of information. It helps the court to narrow down what we're actually discussing or deciding in this particular case. The briefing was very thorough and helpful for the court. Even if we have kind of limited case law on certain things, it's still helpful for the court in guiding it into hopefully getting to a decision. And I appreciate your professionalism and your arguments here before the court. We will take the matter under advisement and issue a decision. Is there anything else in this matter for today, Ms. Kennedy?
No, thank you, Your Honor. We appreciate your time on this case.
Anything further, Mr. Jones
No, thank you, Judge.
or Mr. James?
No, thank you, Your Honor, for your close attention to the matter.
Yes. All right, thank you. We will be in recess for today.
All right. God dang it, man. That's just so frustrating to listen to the city attorney do this bullshit walk-up. Well, we don't know what you really want in the records. Fuck off. You do know what they want. They made it very, very clear. Well, you weren't specific enough. You need to tell us exactly. And I need to know the officer's name who actually did the interview and the date and time that it was. Fuck off. We don't even have that information. You can't. it pisses me off so much. And just stonewall, and then, oh, now I'll have to go think about this for a while longer. And it goes on and on and on. That's probably my biggest complaint about the whole thing. But what do you guys feel on your initial reactions?
Well, I was waiting to see who was going to bring up the post-conviction relief action, you know, and what I'm disappointed in is that nobody raised the issue that while there was a non-dissemination order, Judge Hippler, who has jurisdiction over Idaho versus Koberger since the change of venue, he set it aside. There is no non-dissemination order. They got to start all over again. And secondly, the person who owns the right to any Sixth Amendment is Mr. Koberger, and he could have intervened in this case and said, "Whoops, don't release anything." He owns, not Leander Jones. Leander Jones does not own the Sixth Amendment privilege of Mr. Koberger's potential right to pretrial publicity that might harm him. And in fact, in his manifesto of July 26th, he wants things to be in the open. So it's not Leander James who should be speaking on behalf of Mr. Koberger relative to a non-dissemination order that doesn't even and hasn't existed for over a year.
Yeah, right. Robin, what are your first thoughts on the whole thing?
I really one thing I thought was striking is kind of how you know, James and Jones are kind of almost tag teaming you know, Kennedy in a way, or not like kind of together, uniting in a way. And yeah, I couldn't understand why James thought it was his responsibility, or he could even speak to Brian Koberger's rights.
Yeah.
He has nothing to do with those proceedings. And in fact, there are no proceedings as of yet. So, and like Kathy pointed out, there's no dissemination in effect at this time, and it hasn't been changed. So until Hippler rules on that, I don't even think that should be taken into consideration.
I also there's a point that Leander James made that I really can't stand, but I'm not a lawyer, so I don't know the rules. His argument that, well, if we show people's faces, then the internet will go out and bug these people. And I'm like, for me, that's not a fucking legal argument. You can't do the whole, well, somebody might go pester that person. That's fucking on them. That's
speculative.
Not our problem.
Right. If somebody like who showed up at the Koberger's door the night of the 30th while the house had been broken down and they got wood up, it was mainstream media. It was Brian Enton. Okay, what you do if somebody shows up at Stacy Chapin's door and wants to talk to her, she picks up the phone and she calls 911. That's what she does.
Exactly.
We can't now have a restraint on the First Amendment speculating that somebody might be bothered down the line.
Yeah, it was. It made me infuriated. Well, you can't do this because somebody might reach out to them. I'm thinking that's non-argument. You can't fucking tell everybody that nobody's allowed to do anything because somebody might abuse it. Well, if I put that out there, somebody might pick it up and hit you with a stick. Well, so I guess we can't have any sticks because somebody might pick up a stick and hit it. You see what I'm saying? Like you can't do the whole like somebody might abuse it, so therefore nobody gets to have it. That's asinine. Somebody might cause a car wreck, so maybe we shouldn't sell cars. Somebody might kill somebody if they're drunk, so maybe we shouldn't sell alcohol. Like, where do you draw the line of we shouldn't do this because somebody might abuse it? Like,
right, and this is really a First Amendment issue, and the reason why we're in the pickle that we're in right now is because they overly sealed the case. If this would have been run like any normal case, rather than the two of them, the defense and the state, wanting to hide everything from the public, we wouldn't be right here, right now, looking just at the autopsy report within this past month. By the way, Hippler did unseal December 18th and waited another half year before. That should have been released during the case. And the fact that no one see this interrogation video is absurd. The arguments against that is so strangely. What did you guys think about that?
It's asinine. Payne and who was the other that went with him from Idaho? Gilbertson, go there and conduct the interview. And because it was filmed by Pennsylvania, they're literally going to go, hey, it's not our record. It was your fucking investigation. Your guys did the interrogation. It was filmed somewhere. So Pennsylvania says, you can't have it. That's a Moscow investigation. Payne was the one that interviewed. Payne's like, you can't have it because that was a Pennsylvania investigation. Fuck off. You literally are just, I'm just get so mad. They've been doing this. All of these agencies do the same thing. Oh, they have the record. No, they have the record. And then they tell you, well, you need to figure it out, public. You're not asking the right questions. Well, because you're playing games, you're stonewalling, and you're just saying, and you're making a judge have to come in and make the ruling because you won't use common sense. So, it's
they asked, I mean, EWU asked for this interrogation video, like, well over a year ago, Lee. It's not like this is a public records request from a couple months ago. This lawsuit has been pending since February is when they filed it. So now we're a year plus 2 months. Public's never seen this interrogation video. And I have to ask myself, what is on there that they don't want the public to see? There's got to be something on there, because first thing that they do, they want to show off, and they want to show that, hey, hey, this guy, he thought he was going to pull one up on us. He wound up pleading guilty to everything. Look how great we were from day one. This is
another thing that bothers me very, 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 very much. EWU, like you said, I think it was February or whatever, and then they made an initial request, and they listed exactly what records they wanted. Then they followed up later with another thing about what exactly they wanted. Then we had a hearing where the city said, well, you know what, Your Honor, we're going to need to have a list of what they actually want, which they fucking already did twice. And the judge granted it. Okay, well, you know what, EWU, go give them a list of what you wanted. And I was already losing my shit. They gave you 2 lists already. So then she narrows the list even further, not even asking for everything they originally asked for. And his response was, well, we just got the new narrowed list last week. That's not enough time. We need more. Fuck off! Like
Do you know why they got it last week, Lee? Is because Judge Marshall ordered. She set up a schedule May 18th. She set up a schedule that because these people never responded to the petition. They went strictly with the motion to dismiss, like sort of like a request to dismiss. So she gave them May 18th until July 10th and said, you guys come up with lists. All right. So if he had a problem that it was going to be too soon, he should have spoken. You know what, Judge? Maybe we need a couple, and then we wouldn't have had this hearing until maybe September or something like that. But this has followed a procedure that she put out. And the fact that Leander Jones, they have been neck and neck since the beginning of this case. And as a matter of fact, last year, when people started filing public records requests, the city of Moscow contacted Leander Jones, and the next day he filed the lawsuit. So they have been connected. They know exactly what they're doing.
And I'm trying to oversimplify on purpose Leander James's argument, because families were involved with the murdered victims. No one's allowed to know anything about it because it's harmful to the family. The family would have to relive everything. So this attitude that if somebody gets killed in America, apparently nobody can get anything because it would be harmful to the families to have to relive that event or whatever. Like this would have then apply to every single crime in America. Oh, you can't talk about that because there's surviving family members that will be harmed by bringing up this tragic moment in their life. Like I'm trying to oversimplify the argument, but that's his argument. Like they're going to be harmed by having people find out more details about the murders. So therefore, nobody's allowed to see anything about the murders because it would be harmful to that family.
Right. But, it's insane because the way our system is set up is that criminal trials should be in the open, in a public forum where anyone could go in at any time. Lee, you should have been able to go in and watch any proceeding. But because this was sort of like almost like a national security type of case, because they didn't want the public to know what they were doing. And now we're going to bring in all these other agencies and we're going to rely on what they did and we're going to have that. But, no, you can't see what, hey, you know what? Then don't call Pennsylvania. Don't contact the feds. You do your own investigation for yourself. Now you've outsourced. Mr. Koberger didn't do anything wrong in Pennsylvania. Pennsylvania State Police were assisting the Moscow Police Department in arresting him. You know, so
Exactly.
now you want to turn around and say, oh, no, you can't get, because that's a Pennsylvania matter. No, it's not. You started the ball. You know, this is a result of what you put into place, and then you relied on what they did. Okay.
Yeah.
If okay, you know what? Go back into and take out everything that the feds did for you, PSP did for you, and everyone else, and that's how you should have prosecuted Koberger, just based on Moscow Police Department's investigation. If we're going to get this silly.
It did sound like, unfortunately, it did sound like even the attorney for, now I just closed the screen. Now I don't have their names on my hand. For EWU suggested that the likelihood that Koberger would get a trial would be slim. So here Leander James is trying to say, well, we need to now consider the fact that he filed post-conviction relief and there's going to be a trial. She's like, the likelihood of a trial is still slim. So, but yeah, it's a, I don't know how much legs he has on this, but it seems like
he has no legs. He's ridiculous. He doesn't represent Mr. Koberger. You know, if Mr. Koberger didn't want these records to come out because he was concerned, they could have moved to intervene, just like, you know, Laramie and the Chapins did. He owns that Sixth Amendment privilege, not Leander James. Leander James doesn't give two watts about Koberger and his privileges. He's concerned about making sure that this case stays under seal. Now the public can pay for it. You know, God knows how many hundreds of thousands of dollars we've all paid based on the large federal presence there. That's not Moscow paying that. So what? Should we ask Latah County to reimburse the federal government for all the tax dollars if we can't even see what's going on in this case? Have every person in Latah County write a check right now to the federal treasury for $5,000 and reimburse everyone who paid taxes in 22 through 25 for their investigation. This was a Moscow Police Department investigation.
Right.
Yeah, good point.
So to my way of thinking, any officer from Moscow and the prosecution, if they have viewed any video from any other state involved in this case, to me, they do have custodial, possession of these records. So therefore, it should fall that they have to produce these records. You can't look at it if you don't have possession of it. It's either on a DVD, it's on a CD, it's on a thumb drive, it's on, I don't care, pigeon carrier, papyrus paper, whatever.
Listen,
you have possession of this. You have viewed it, so cough it up.
We 100% know that they have possession of that interrogation video.
Yes.
Because when Payne, who did the interview along with Gilbertson, and I'm disappointed EWU didn't raise that, it was Payne and Gilbertson. Maybe the FBI guy was in the background. I don't even know if he was in the room, but it was Payne and Gilbertson who interviewed him. And Gilbertson audio taped that interview, all right, in his pocket. So, so we can't hear this. We can't watch this interrogation video. Why not?
Yeah.
Why not? It wouldn't exist if Payne didn't fly out there.
Well, to me, one of the most aggravating moments of realizing the absurdity of their argument was when it was clear EWU had asked for the initial interviews of Dylan and Bethany, the survivors, and the city's response was, well, they weren't specific. We need to know the officer that interviewed and the date and time that the interview was. So we apparently as the public need to know exactly what time, minute stamp it was done at and where it was done and who the officer was involved, because it's not good enough to say, can I please see the first interview that Dylan ever did? I'm sorry, you need to be more specific. Where was that at and what date was that at and who was involved in that? We can't find that record. And again, my counter to that is, if you can't find it with that kind of specificity, then how is Ann Taylor supposed to prepare a defense? You tell us Ann Taylor had plenty of time to look at all the discovery, but you're like, man, the first interview Dylan did, you're going to have to be more specific. I can't find that. There's a lot of data in this. How am I supposed to find the first interview Dylan ever did?
And that was my point that I was making in the chat. You categorize and catalog things as the information is coming in. You have people that can do that. You can request overtime from the city in order to provide personnel who will do that. I've been in administrative shit like this for over 25 years in my lifetime. I'm going to be 55 next week. So if I could take it as a private person, as records come in, as surveillance video comes in, and you have officers who are supposed to do this, as well as administrative personnel who can sit and do it as it comes in real time. And then that avoids this kind of horseshit.
Well, you know what, Robin? I think that we got a little taste that things were not done in real time because some of the reports weren't written sometimes for like months later, a year later by these cops, you know? And I mean, we know from say, okay, let's look at Payne's report. Payne did not write. This was the most important, probably the most important interview he would do or anyone would do is the Koberger interview. 2 a.m. He was arrested, what, 12:30? That's how quick it was. Imagine how, to see his body language, to see how he responded, plus what he said. He didn't write that report until March because the defense asked for a copy of his report. So he's now backtracking 4 months, but he clearly says in there that the interrogation video was docketed into evidence by him. They have it. You know, if they don't have it, they need to go find it. They need to go find it.
And there's another thing that really sticks in my craw. Why aren't these people required to write a report within like 48 hours of a major quadruple homicide or an interrogation?
I know. It's like everything. They're flying by the seat of their pants. They're flying by the seat of their pants in terms of how they did things. But you know,
that information, that pertinent information is lost because the longer out you go, the worse your memory becomes.
100%.
Right. And had there been a trial, you know, that could have been argued by the defense. Well, you didn't write your initial report about this until 4 months after the events happened. So how are we to know that your memory of what happened 4 months before is accurate? Like you could argue that in front of a jury. Like, so you didn't write this report for 4 months after, and maybe you did a little bit of writing after the fact of things that you knew later on. You know, like we need to have your thoughts in the moment, not like after you've been listening to the case for 4 months.
Right. It's like asking someone what they had for breakfast a week ago.
Yeah, I mean, go back and with everything every day, every minute they were working this case. Okay. And so now I got to turn back the clock to December 30th, you know, in March and figure out what happened. Okay. He's got the video. Well, he's got the video. He can look at it and he can, you know, write his notes from the video, but maybe there were other things that happened before, you know, when he's walking down the hallway with Koberger. Imagine that sight. Payne walking down the hallway with Koberger with, you know, attached to him with the whatever, the wrist things.
Right.
Maybe, you know, something happened there. And the more out in time that it happens, you're right, your memory just gets fuzzy. I don't remember what I had to eat yesterday. I remember what I had to eat yesterday. But as time goes on, you forget because you're involved in what's the crap that's going on today.
And what about, like, this is a side tangent, but what about Leander James trying to argue that, well, you don't understand the pressure of how many people I have to fend off after he filed PCR. I have to deal with all this shit. And I'm like,
oh, he loves it. He loves it.
Exactly. It's an honor and a privilege, but it's a lot of work. I gotta deal a lot of public people talking to me.
Oh, I mean, you should, I don't know if you remember the first, but I mean, he just bragged about how he went to the legislature and he helped to get the new law passed. Nobody would know who this guy was. Same with Cy Ray if it wasn't for this case. He took this case on pro bono. Maybe he wanted to do some good for the families, but he did it also for the free publicity. You know, I'm sure he's gotten business because of his involvement in this case, and he gets bragging rights and everything else. But what I wanted to ask you guys is, what do you think her ruling is going to be? I mean, pure speculation, and maybe the people in chat could also, if they have any thoughts on how they feel Marshall's going to rule.
Yeah, I just want to say real quick is, please be respectful in the chat. I know that we can all have varying opinions, and sometimes, you know, respectful debate is good. Name calling, if you're resorting to name calling, then you've lost your argument. You can have a spirited debate, and we're all about that here. You know, so I just want to remind everyone of that.
Right. Yeah,
so
I see.
What I think is going to happen is, so
stirring up. There's one person who's been stirring up for a while. I'm wondering who that is.
Well, and not only that, but they're typically fairly respectful. And I think we should afford them the same consideration. Myself included, I might be passionate, but I generally don't resort to name calling or anything like that. But I don't know which way she's going to go, because the thing of it is, I think she's trying to walk a fine line. She has
Yep.
to live in Moscow. I have a hunch she's going to uphold at least some of what Jones and James are trying to do, but I'm hoping she at least gives in to something the EWU is after, especially the stuff that they really drilled down on and were very specific about.
Exactly. Exactly. My prediction, having said, watched her now 3 times, last year, Laramie et al., they wanted just basically that whole house shut down. I mean, they didn't want any pictures of the house. They didn't want any photo, nothing. And she didn't give them that. She said basically body fluids and photos of the bodies you can't publish. Okay. But look at what ISP has released. It's sort of like it's toothpaste out of the tube already, guys. You
can't take it back.
You can't. It's out there. It's whether you like it or not, it's out there. And I wish that EU would have pointed that out, that the Idaho State Police has released. They're not bound, and it is out there. But what she did last year is she did not give them everything that they wanted. That's why it's a permanent partial injunction that's been in place. They're speaking, when you hear the injunction, that is the Laramie et al. Injunction that was issued last October 1st. It followed a hearing, I think it was around the August 28th. So I predict she's usually about 6 weeks in terms of when she makes her rulings. There's no guarantee she's going to do it here, but she did the same thing on the motion to dismiss. Her ruling denying it came out about 6 weeks after the May 18th hearing. So I'm picturing in about 6 weeks, maybe a little bit more, maybe a little bit less, that we're going to get a written decision. And I think she's going to split the baby down the middle. She's going to not give EWU everything they want, but she's going to, give them some things. And I think that like the interrogation video seems to me, that's a no-brainer. And that's what they've wanted above all else.
Right. And we should all be able to see it. There is no excuse at this point, this far out, because he has not been granted PCR yet. So therefore, like you said, this has been going on since what, February? So this is, been filed long ago and should have already been released.
Yes, exactly. I mean, they were supposed to have the May 18th hearing. EWU had said, you know what? They had an opportunity to respond. They just decided that they were just going to stay with the motion to. And I said, what the heck is this? When I saw their response come out, I said, they're not even addressing any. So they got an additional 3 months. They got an additional 3 months here. This hearing was in May. We're in August right now. Right? And now, and these records requests were made, like I said, between June 30th and like September of last year. They kept narrowing down their records, and they said that they spent $20,000, in terms of what it cost them time. The attorneys had to look over it. The attorneys had to research. And now, this has been going on since February. But I predict, like I say, I think she's going to release, I hope she releases the interrogation video. I think there's a reason why they don't want the public to see it. Some people thought, well, maybe they didn't Mirandize him. But then I thought, if they didn't Mirandize him and Taylor didn't look to get that, she's really then asleep at the wheel. I think it's something else. And it may be what he was doing, because he said he worked for 2 law enforcement agencies while a student at WSU.
The question I partly have is, maybe it's a stupid question, but during the discovery thing, did they not have to turn over to Ann Taylor the original interrogation in Pennsylvania, because they did the same thing to her? Sorry, that's not our records. That's, we're giving you our records, but that's not our records. That's Pennsylvania records.
I believe that she got it. They had asked for it in discovery fairly early on. And that's the only reason why Payne created his report, because Payne did not have a report. The discovery request came, Payne wrote his report, and they're saying that they provided it. So Ann Taylor might have that interrogation video and has had it since May of wherever it was of 2023. So don't sit here and tell me you don't have it, because Payne put in his report that he placed it into evidence. And
so therefore, to me, if it's in any possession of any of the court counsel or the police, whether it be in Moscow, it's Idaho State, whatever, they have possession of it. They should have to release it.
Possession, custody, and control, right?
Yes.
There's multiple copies of this video. You got one in Pennsylvania, you got one in Moscow. We want the one that the Moscow Police Department, that Detective Brett Payne says he put into evidence, that was relied on, like everything else. All right, if you're not going to turn it over, then you shouldn't have relied on it. And this nonsense,
That's right.
It's the state attorney. No, state attorney didn't do the investigating. It was the Moscow Police Department who did. They were lead agency. Remember what Fry said? We're in charge. The people who helped him, including the feds, had no jurisdiction. They needed to be let in by the Moscow Police Department. And now you want to turn around and say, oh, we don't have custody or control, then you shouldn't have relied on those records, and you shouldn't have asked these other partners to do your work for you. And in future, then no other law enforcement agency should be able to rely on anyone else.
Right. That's what I said. It was, I don't know, a few weeks ago, I said, my message to all law enforcement is to do your own work and don't depend on other agencies. I realize you can ask them for assistance, but do your own investigating first.
Right. And why do you have to have all these different police departments? If Moscow Police Department is, 25,000 people, is that small, then maybe you should merge into Latah County. You shouldn't have two police departments if you're that small.
Do it all the time. They
merge into, just have the county police then. Then you don't have to pay two different, double salaries. Oh, well, we can't investigate this because we're too small. Well, if you're too small, then maybe you shouldn't have jurisdiction because you're too small.
Yeah, you can. That leads me into being able to effectively police, serve and protect the community if you are that small.
You almost get the impression that MPD is just basically their main responsibility here is to guard that college, that university, and maybe do a few other things. But they're basically, in a lot of ways, a campus, a police department, and they do a few other things.
As their contract obviously shows to me. That's essentially what that contract says.
Right.
Is that they are, in effect, they have a contract. They are operating on, a lot of the terms that the college lays out. So they're almost like a rent-a-cop for the university.
Right, exactly. Rather than having the university go like other universities do, they'll go out and hire their own. No, I mean, you have MPD, who is the SRO is MPD. They make overtime, which is great for those cops, and then you want to turn around and say, oh, well, we're too small. We have to bring in Latah County. We got to bring in the ISP. Well, if you're that small, like I say, maybe merge into the Latah County Sheriff's Department. People don't have to pay your salaries and the salaries of Latah County. If you're still too small, then merge into the Idaho State Police. That's it. You don't have to have all of these agencies.
Yeah. Yep.
I'm trying to squeeze in a little bit of lunch because I'm starving, so I've been stepping away. I'm listening to you guys, but I step out to the hall. But and I'm going to do that one more time, step away. But I want to keep the conversation going. People have questions about it. I'm glad that you guys joined me for it. I'm glad that it actually got pulled off. But man, it was super, super frustrating listening to the state. The state is irrational in my opinion, and they're kind of getting away with it because every single time they stonewall, we just delay another 6 weeks or whatever it is to make another decision, and then they come back and then they stonewall some more, and we have to have another 6 weeks. That's what it feels like at this point.
Well, it really does because like these go back to when these public records requests were submitted as early as June 30th of 2025. We are now in August. Okay. It's a year and 3 months on top of all of the other public records. I feel like EWU, in a way, is speaking on behalf of everybody who's filed a public records request and was given this
Yes,
runaround. And you got to pay
and
all
they
this
are.
money. You know, it's like
Yeah.
going back to what Lee said. Oh, you got to be specific. I was like, I mean, how many quadruple unalivings, Moscow Police Department, have you worked on that you need an address, you need a time?
Right.
Is it going to be anywhere else but November 13th at, at 1122 King Road? If you've had another one, we didn't hear about that. You know,
No,
it's just,
we'll look at Bianca. We didn't, until recently, we didn't know that she had been called back 5 times to talk to the cops.
yeah. Or
5
that there
times.
was
So
a
how are we
potential.
supposed to know the date and time of all those times when that hasn't been disclosed?
And then, right. And then, what about, why are they redacting JD's statement to the point that we didn't know that there was a rug possible connection here until just recently?
Exactly.
Okay, that interview
Exactly.
took place, what, in December of 2022? Why,
Right.
why hide that? It's like they're hiding things. That's the
Yes.
impression I'm
And-
getting.
and-
Otherwise, that wouldn't have been redacted.
And you have to ask, I mean, yeah, maybe it's a little embarrassing for the families. They don't want to think about their children participating in these things, but come on. In the day and age that, we're in, and I'm sorry, a 20-year-old, you're responsible to you're old enough to take responsibility for your actions. And it goes to victimology.
Yeah.
If you are involved in a drug scene, even if you're not selling, but you're buying on a regular basis, you have pertinent information into the area's drug culture.
Yeah.
Right. And people that are involved in that culture are going to be coming into, to your home or around your home or
Right.
have access to you. And how many times,
Yes.
oh, this is a part. Oh, no, there wasn't anything going. So is that the only rug connection? Just this one that just happened to come out? During all these parties, what were they doing? Drinking, eating cookies and milk and studying for their algebra exams all hours of the night?
Right.
Maybe where there's smoke, there's fire. And how many times was Mr. Koberger, treated like a subhuman because he got
Right.
involved with some
Right.
rugs when he was a teenager? He's not the
I wanna-
only. I've said this before. A lot of students do.
Right.
There's another issue that I want to bring up that's indirectly related, but I had a recent records fight with Carroll County in Indiana, the Delphi, Indiana case, Richard Allen. And I was asking about crimes. I wanted a list of violent crimes committed along near the Monon High Bridge for a period of years before and during that murder. And they came back and they said, Carroll County came back and said, it's too broad. You need to tell me what date and time the incident happened. And I responded and I said, this is a request for discovery. I don't know what I don't know. I'm looking for a list of things. And their response was, we're a small town. We don't have systems that can just pull out information. Therefore, you're denied. Yeah, like I have to tell them exactly what incident I'm talking about. So how do you know what you don't know? Like I said, literally, like I'm just looking like how many murders have you had along that trail? How many rapes have you had along the trail? I want an index. And they're like, we don't have time to make that index
wouldn't
for you.
that be just something that you plug into some type of a database and poof, then you have the reports?
They have to provide that kind of thing to council, to the township and things like that for, a lot of times for funding,
Right.
to justify funding for things. So if you can say, yeah, crime's down and this is, but again, in Moscow, we all know they don't take reports half the time anyhow.
Right.
So,
Right.
but that's just bullshit. And again, it goes back to records keeping and either being lazy or just not giving a crap. But this is why it's important. The grunt work is important because now here we are where we have, the city of Moscow saying, well, it's so, data we have is just massive and we don't even know what all's there. How can you effectively serve your community in any court case, even if it's a damn traffic violation, if you don't have everything in this day and age with all of the modern software systems and everything? How can you effectively serve your community if these records are not properly preserved?
Hey,
And
Robin, I'd like to know how much money they got. They got federal and they got state funds. What did it go to if not to help to put together a system like this to organize their records? What was that money spent on?
Here's another point I want to bring out, because I keep thinking about this and then forgetting to mention it when we're talking. Christopher Wickham, when I interviewed him on the book Broken Plea, he pretty much hinted very, very clearly that when he was looking at the evidence that was presented to him, the discovery that the prosecution had, and Christopher Wickham was allowed to see it before writing his book, he said he found many things that he all but said were intentionally misfiled under folders that were in the wrong area where you wouldn't expect to see it.
Wow.
And he kind of hinted that they did it on purpose, that they put things in folders that were improperly labeled. So does that allow them to do the game of, well, we looked for the record you requested and we can't find it because they purposely misfiled it in the wrong place? And then they can hide behind that, well, we looked where you told us to look and we can't find it. But again, Wickham pretty much hinted it looked as if they had intentionally hid stuff in folders that were mislabeled so that it would be hard for Ann Taylor to find and hard for public records requests to find because it's mislabeled and misidentified.
Oh, wow.
Right.
I mean, you're just so dirty if that's true. I mean, there's no call for that, to hide things. You know, it just keeps going. Why do they want to hide things? It's like they
if your
don't want it
investigation
out.
is clean, if your investigation is on the up and up, why do you have to resort to all this bullshit?
All these games. I mean, what are they going to do if he does get a new, I would say it's not a new trial, it is a trial. What are they going to do? You know, and he starts, you know, asking for discuss. He serves, you know, submit everything you haven't submitted before, you know, under new folders, helping, you know, with the Chris Wickham, under the new folder, submit that right now. You know, I mean, this is like a new Koberger almost. This is Koberger 2.0. I think he was, you know, really listening and accepting, maybe without maybe towards the end, he started to get a little bit concerned. But I don't think, like this time around, if he doesn't like what this attorney's doing and he doesn't feel that he's being represented properly, I think he's going to say something. You know, I think he's going to be a lot more because this is it. This is it, Robin. You know, if he doesn't succeed here, he's done. You know, he will, you know, perish in prison. That is it. This is his last shot. And I don't agree with either of them who say that he doesn't have. It all depends on how well they put together this amended petition for post-conviction relief, which is what you see when pro se parties get counsel, so that it's put together with the bells and whistles and everything that it needs to be, and that it gets him into where he needs to be in terms of both standards, Hunter and also Garza, both.
Right. So and it has to be done properly by a lawyer who's actually interested in doing right by the case and doing right by Brian, not someone that, you know, Hippler's just throwing in there and saying, you know, well, you have a lawyer, so everything's good.
Yeah, I think he's going to be really on top more now, because this is basically his last lifeline. You know, if this gets screwed up, you know, okay, well, we're going to appeal based on what was done in front of Hippler. So they got to make sure that they throw in everything into the soup, you know, into the mix right now, so that if Hippler still denies, then you got a basis. You could say, look, we brought this before Judge Hippler and he denied it. You know, it's just like when they raised the issue that the media had gone to the Supreme Court on that gag order. The Supreme Court said, you got to go, we're last impression, we're not first. You got to show that you brought this before the district court. He had an opportunity to rule on it and ruled improperly for you to be able to have anything on appeal. So we're going to find out very soon right now if this guy's legitimate. You know, I would argue it's not just that he's got to do the right thing by his client, but he could make his career right now. He might say, hey, I don't want to be doing landlord tenant anymore. Here's my opportunity to become the next whoever, you know, Alan Jackson, you know.
Unfortunately, if Brian Koberger complains about his new attorney, Hitler's just going to use that as, yeah, whatever. You're complaining about every attorney. Like, you've been given 2 different attorneys and you don't like both of them. You're just a whiner. You know, it'll be perceived as, if Koberger says he's not liking the new attorney, it'll just be perceived as, of course, no criminal in jail thinks that they got a fair trial or that their lawyer was good. And so you're just whining again. And that'll play with a lot of people as well, I think.
Oh, yeah, that's true. But I mean, maybe he'll complain to the point where it's not public, and then he can go and say, well, ineffective assistance of counsel. He didn't listen to me in post-conviction relief. I told him that I wanted to do this, and he didn't. So, you know, I think he's on top. But this guy, like I said, you know, everybody is just, first off, he has done prior PCRs. He's done post-conviction relief action, so he knows what the system is and what needs to happen here. But I think that there's something very self-interested for him. Does he want to stay in this small town the rest of his life and do landlord tenant in the odd, or does he want to maybe make, you know, an entrance into a national arena? And that's what this case could present him for.
Definitely. Definitely. I wanted to ask you guys, how do you think the criminal investigation into the leak will influence, if Brian is awarded a trial? How will that play into that trial? I don't know the answer to that, and I didn't know what you guys thought about that.
Well, can we maybe like work out like a scenario, just like let's just say that the leak is who? Detective Brett Payne. Just throw it out there. I'm not saying it's Payne. I'm not saying it's him.
No, we're just speculating at this point. Or anybody on the prosecutor's team, even if it might be a clerk or somebody. I mean, you know.
Well, you know what? Whoever that clerk works for,
how would that affect that?
The boss is responsible. If you have a clerk come in to help you, you can't say, "Oh, wow, the clerk went out and then, you know, gave his stuff to Dateline, so I'm, you know, my bad. I'm not. No. You are responsible, and that's why Hitler wanted the name of everybody who had access to anything that was under seal in the case. Let's just say it's somebody who's central. You know, he's got a Sixth Amendment right to be able to confront witnesses against him. So he would be going to trial if he went to trial last year. And let's just say, we're just saying hypothetically that it was Payne, right? And And Joanna, I was watching. I was going to say, see what Joanna Way is saying right here, Lee. I've got
a clip of it up right now.
Excellent.
Yeah, I've got a clip. I've got an 11-minute clip I thought we'd play because it's Wickham talking about how the DNA does not match Brian Koberger.
I love it. I mean, I didn't even get to that part, but I like the way that he was interviewing him. But let's go back to my hypothetical that it's Payne, somebody that was really central to the investigation. Whether you think he was or what, he signed the warrant affidavit. It's him. So Koberger would have gone to trial, questioned him, and not really had a meaningful opportunity to question a witness against him because he didn't know that it was him who did the leak. Then I think that he should be entitled to some sort of sanction, and maybe whatever, have him deemed, a Brady, whatever, however it works. But I just don't think, he leaked the information. All right, we're going to ignore that. Hitler's going to have to do something about it.
Right.
And maybe, whatever he touched gets thrown out of the case. That's what I would push for.
I know. And that's the thing.
That's
like
possible.
Payne was in a position for this trial that him and everything he touched could have got tossed. And again, the prosecution's case is down the toilet if Payne's involvement in the case gets tossed because he's all over it.
He's all over it. Everything started with him.
Yeah.
The PCA is what led to the warrants or led to the arrest and then the warrants. And that's why we say if the foundation of the home is screwed, the home is in a potential to come falling down. And this case was just so questionable from the you look at that PCA, there's so many errors in it. You know, so I mean,
Yeah.
and not little I mean, people are human beings. We all make typographical errors, but I'm saying putting the victims in two places simultaneously, that can't happen. You know, calling Koberger different names and citing to different phones and saying that a city that he supposedly went through that was in Idaho was really in Washington. I mean, it just shows it was sloppy, sloppy, sloppy. And something
Yeah.
like that should have been as close to perfect, but I think that they were in a rush. They needed to get it in before school started, and that was the bottom line.
By the way, I want to comment just briefly, not long, just briefly on Spider's comment. This was exactly the prosecution's argument. We gave you 68 terabytes of information. We gave you all the discovery, and it's not our job to do your job for you. So go find it. But then you've got Christopher Wickham saying they purposely mislabeled stuff, misidentified stuff, put it someplace. So you're right. You're right. That's exactly what the law enforcement did in this case. Is like, hey, we gave you 47 hours of somebody rambling about bullshit that has nothing to do with the case and added it into this whole big huge. We just gave you everything and then some. It's not our job to find the pertinent stuff for you. That's your job. Oh, you ran out of time? Too fucking bad. You had it in your hands. They overwhelmed them with data on purpose, mislabeled and misidentified stuff, and then said that you've had it the whole time. Too bad you couldn't find it. Wah. And
well,
that's bullshit.
wasn't that her argument for more than 2.5
Yeah.
years?
Yeah.
They either were not turning things over, or they were turning things over like it was this massive trying to find a needle in a haystack because nothing was labeled. And
Right.
then it goes
Yeah.
back, Lee and Robin, to what I've been saying all along. How does she get up in open court and tell Judge Hippler, we got all the discovery and reviewed it for him to be able to make this guilty plea today?
And here's the funny
Right.
thing too. Here's the other game they played, in my opinion, with Ann Taylor. Ann Taylor, they said, specifically requested to get discovery as they got it. So here's and like Robin was saying, listen, this is the devil's in the details. As Robin said, when you get something, part of the intake is to categorize it and put it somewhere. But what they did is they said, we gave it to you exactly how we got it, which is just a massive data dump of shit coming in from everywhere.
Mhm.
Now, you know damn well they were organizing it as it came in. But what they did is they gave her unorganized random shit that was coming in and said, it's not our job to give you organized files. We did our own organization. You should do your own organization. So they kind of played a game. Yeah, they kind of played a game with her because they didn't give her the organized discovery that they put together. They said, no, that's your job. You asked for the discovery as it came in. We're giving it to you exactly as it came in, which may or may not be true because she got it in different times and had to fight and had to say she wasn't given all discovery and had to get more. So she wasn't getting it as they were getting it. She had to fight for pieces of it. So it was just all a shell game, just moving shit around and making it confusing for her to figure out where shit was coming in, and then saying, hey, it's not our job to make your defense. You make your defense. Go find it.
Right. And then, going back to the PC of post-conviction relief, I think that he would have great grounds, under a Garza theory, that his attorney, who is obligated under the Idaho Code of Professional Conduct, it is a legal standard. You cannot, this nonsense that has been going around. Oh, she's up there. She's, fabricating. She cannot do it. The judge asks you a point blank question. You have to show candor to the tribunal. So if, we don't know at this point, but how, on a scale of 1 to 10, how likely, if she's saying for 2.5+ years, I don't have discovery, or it's in this big pile and I can't find what I need, then suddenly at the most critical stage in the proceeding, oh yeah, we got everything and I was able to see it. What are the chances? And so Koberger's relying on her to advise him, and she hasn't gone through discovery. Is that ineffective assistance of counsel? Will that get him?
Oh yeah.
Will that get him? This is why I say, these people that say, oh, he's automatically out. It depends on how good, I think, this is my opinion anyway, that this attorney puts together what he needs to put together right now.
Yeah. And I hate to say it, but if Koberger had Luigi Mangioni's attorney, Karen Ignifilo, he definitely would get a trial. He would definitely get a trial.
Yeah.
Because
we wouldn't be where we are right now.
She would tear them. If she had it early, we wouldn't be in this situation. But even if she took it on now, he would definitely get his trial.
Oh yeah, absolutely.
Right. Right.
Do you guys want to listen to this 11-minute clip?
I would love to, because Lee, I
Sure.
started to watch. Is this Dak Shepard? Because I started to
Yes,
watch
Jack
it,
Shepard. Yeah.
and then I said, "Oh my gosh, the hearing's on," and I stopped. I didn't get to the
Oh,
DNA part.
Well, let's look. This is just going to be it's like a 2-hour interview or something like that, but this is just the clipped out 11-minute DNA part that I thought was, because I was like, we don't have time to play 2 hours, but we do have time to play.
He goes into all his other stuff like Ruby. I don't
Yeah.
want to see. I want to hear about Koberger.
Yeah.
So
let's play this real quick before I put it full screen. This is the truth about the Idaho murder suspect, armchair expert with Dak Shepard. So make sure you like, subscribe, all that good stuff, to give him some love for playing this portion of this interview.
I would say, conservatively speaking, there were 12 really hard people that were named in police files as suspects that I don't talk about in the book because for various reasons.
Yeah.
But the cast.
Yeah. And by the way, it's a good thing for us to pause often so we don't just completely rip this thing off. 12, as Wickham says, really good alternative suspects. Only 4 of those made it before Hitler in the alternative suspects list, of which he rejected 2 of them because they lived within walking distance and the killer came by car, so it couldn't have been them. But anyways, so it's funny because he lists 12 alternative suspects and really good ones. And by the way, he had an entire chapter. Wickham had an entire chapter removed from his book by his publisher because of that chapter. That chapter was all about alternative suspects, and he listed several people in there. And they said,
Lee,
no, that's getting too close to naming somebody else.
Gotta ask you a question.
Yeah.
Do you have any? I mean, I want you to speculate. Were these 12 alive or unalive?
Alive.
Do you think?
I well,
Ooh.
one may be unalive. I don't even use that word. One may be dead. There you go. One of the alternative suspects may be dead, but there are several that were big names that are clearly alive.
People that we know of, or other people?
Yes. Yeah.
Cool. Okay. So there's 12. Wow.
Yep.
Okay.
So let's continue on.
Of characters in this thing is staggering. It's unbelievable. How many people could have been responsible for this? They had white cars that matched Koberger's. They had relationships with the victims. They were there's so many different things.
Yeah. Also, cell phone tower pings in a town of
Right.
that size. It doesn't really. I don't know how much that.
But I'm glad to know that there were other people that they ruled out. Because hearing this, I'm like, how did they pick this random?
Well, okay,
person?
let's talk about that. That's so important.
Yeah.
Well, how did they pick this guy, right?
Yeah.
And that's the question that nobody's really resolved to this day. The narrative says that police found this white car. Brian Koberger had a white 2015 white Hyundai Elantra. At that time, these car manufacturers have a subconscious. They pick the same model and they all make a version of a small SUV or whatever. They're all very similar. Yeah. At that time, many manufacturers, Mazda, Chevy, made cars, 4-door sedans that had the same contours, and they had a window behind the door in the back that was kind of like an eyelet that went up like that. And when the FBI came in and identified these cars, they basically went to surveillance cameras everywhere around Moscow, and they found cars driving around at that time of night, and they tried to make them look like they were all the same vehicle because they were white. They were.
Yeah, and again, we need to pause fairly often. Again, when I went with JJ from State of the Deep, there were white fucking sedans everywhere. There was 20 of them parked in the King Road residence neighborhood that I've got it on camera. I've got the video footage of me driving past a million cars that look like that. There was like 30,000 white sedans in the area. And so again, and that's what Ann Taylor argued in part is this. You continually saying, here you see suspect vehicle 1, and here you see suspect vehicle 1, and here you see suspect vehicle 1 is misleading, and it's for a jury to determine whether that's even the same car.
100%.
But you telling them all the time that that's the same car is going to prejudice a jury. And they're like, and Hitler allowed it. Nope, too bad. We're going to show all these video footages and call them suspect vehicle 1. And her argument was that's prejudicial. That could have been 5 different white cars. But you're just going to tell a jury it's the same car, and they're going to be like, okay, I see a white car. I saw a white car. It's the same. It must be the same one. You said it was. So it's crazy. All right.
4-door, and they had the window.
It was the only part I would have been useful in.
Oh, you would have.
Yeah.
Was it like because of the camera in the driveway?
Yes.
Okay.
Ring
got it,
cameras,
Got it.
surveillance cameras outside banks,
ATM,
ATMs.
yeah.
Exactly
Oh, I
right.
see, okay.
Exactly. So they came up with this white car, and
Okay.
the white car was seen on that same camera that I just mentioned, that 1112
Yeah.
King Road camera. So they put it all together, and they said it's all the same car, and they tried to. Nowhere does it show Brian Koberger in that car, and many places in the police file I found cars that were almost identical. Elantras, white four-door sedans, windows fit the profile.
And by the way, this is another point I have to make. They make a big deal. They have for a long time made a big deal that Brian Koberger went back in the morning. So
Right.
one, there is no video, never, that has surfaced that shows Brian Koberger behind the wheel of the car, nighttime
That's
or
right.
daytime, the day of the murder, the night of the murders, or the morning after when he supposedly came back. You can almost argue, well, we can't see him because it's dark and whatever. Great. So what about when he returned the next day? Where's that video footage of Brian Koberger clearly behind the wheel of his car driving back the next day in the white car during the day? You have no footage. There's no footage of Brian Koberger in the car. There's no footage of whether or not there was 5 other people in the car with him. There's nothing. So we're going on a video footage and saying it's Brian Koberger driving alone, and you can't see the driver, nor can you see how many people are in the car with him. So those are big deals, in my opinion.
Profile. So that was how they said they found Brian Koberger, because of the car, right? Because of the video camera. The next thing is the cell cam. The FBI has a team called CAST, which is the Cellular Analysis Support Team, I believe. So they came in and they did an analysis. This is very common. If a crime occurred someplace down the street, CAST would come in. It's in television shows all the time. They call it dumping the towers. You dump the cell phone towers, you gather, and I've seen them. Hundreds of thousands.
Yeah.
It's just line after line, phone number. So that's how they zoned in on Koberger. But here's what they found out. His phone was shut off at 2:54 in the morning, and it didn't come back on until 4:48. And somebody else, maybe I'm off by a minute, but not much more than a minute. So for those 2 hours around the time of the crimes, his phone was turned off, and his phone pinged earlier, and his phone pinged after. So many people speculate. I speculate in the book. I don't have theories, but I say this is what the evidence shows, because I obtained all the FBI CAST data. And I obtained the report that they prepared for trial. The CAST team had a thing to hand out as an exhibit at trial. I think it was 31 pages, and it looked like an 8th grade science project. It looked like a PowerPoint that had been printed out on paper. It was like standard colors, and it had a picture of a cell tower that looked like an evergreen tree, and one that looked like a cactus. And these pictures, and I'm reading this thing, and I'm going, "Come on, guys! You know, I mean, you're the FBI, right?" Sorry. Sorry. I was surprised at it, but it showed this.
Well, one has to note that Christopher Wickham, former FBI, is always apologizing to law enforcement. Like he's writing a very fine line. He's trying to suggest in his book that law enforcement did some fuckery in this case, while still wanting to be friends and buddies with his law enforcement buddies, who probably his law enforcement buddies is who gave him the discovery that he's talking about. So that's kind of funny, because he's got to play this game of like, hey guys, sorry I'm pointing this out, but it did look like shit.
Well, he's talking about a couple of Mickey Mouse pictures over here when he goes, come on guys.
In order to dump a tower and to triangulate a cell phone call, and I know this unequivocally because I've been involved in these before, you have to be able to do the math. You have to triangulate. In order to do that, you've got to have
3 points.
Thank you.
Yeah.
Or you've got to have a preponderance of towers that would allow you to narrow down, because a cell phone tower will ping on a tower, and if it, for various reasons, it might go to this tower, this tower, this tower. All that data gives you greater specificity in terms of narrowing it down.
Yeah.
In Moscow at that time, Brian Koberger's phone was AT&T, and the AT&T towers, there were a very, very small number of towers. So they could only narrow down those pings to within what I estimate to be a 10-mile distance. You could be 10 miles away, it would pick up that phone tower. If there had been 2 or 3, then they could have found something more. They didn't have those things.
Yeah.
So Bill Thompson goes out and says, we narrowed him down to within 200 meters or whatever else. And I look at this data and say, oh, you can't.
How?
Yeah.
How?
Yeah.
I mean, I have the report. I mean, it would have come out at trial. So the next is cell tower pings, and a guy named Cy Ray was the defense expert hired by the defense to be the defense expert. He was a cell tower analyst, and he just came out with a book, I think last week. I don't know what it's called, but he talked about this in general. But there's a section in the book about this case, and he says the data was horribly flawed. It was terribly misrepresented. It was the thing was a debacle, and he was going to testify at trial to the insufficiency of the cast analysis. So that's the second pillar of the defense. The third is DNA. So everybody that knows this case knows that Brian Koberger's DNA was found on a knife sheath in the bed on the 3rd floor. The evidence shows that the knife sheath may have been found on the floor and moved to the bed by police. And I say that for this reason. So the Moscow Police Department sealed the crime scene. They go to a judge and get a search warrant. The search warrant was done by Nunez, who in the search warrant was looking for a gun and bullets because he thought he shot himself in bed.
Right.
So they go and do the search, but the search was actually done by the Idaho.
And that's an interesting point. Nunez said very early on body camera footage, it looks like a murder-suicide. And the is it Gunderson that was with him? Or
Warner.
was it Warner? Warner said, "Where'd you get that?" Like, so one officer sees it and like, how did you jump to the conclusion murder-suicide when the other officer didn't see it that way? But it's interesting that he's saying, and he was still looking for a gun because he assumed that Ethan had shot himself after killing Xana. And that was his initial conclusion walking on the scene. That's hard to wrap my brain around, how Nunez came to the conclusion of murder-suicide.
I know.
Yeah, because knife wounds are different than a gunshot.
Right. I just, and even Warner's response, how did you get there? It suggests that it should have been obvious. It was obvious to the other officer. Where did you get murder-suicide from looking at this? Why are you looking for a gun? And if he shot himself with a gun, how could you not see the gun?
Right.
Like,
where's the firearm? Where's the fire? Unless he's thinking it's buried somewhere and they got it. They can't move. They got to get the warrant.
They can't move the sheets without getting a warrant or whatever.
But you know, Lee, I mean, let's face. All right, he was a young cop. I think even at the beginning, Christopher does mention that he was young. He, a couple of years, but he was a paramedic, I think, before he was a cop. So you would think that he would have some knowledge as to what what it would be. But I know that's such a big. I mean, everything about this case is a mystery.
It's so weird. It's so weird. It's just one of those things that just when I hear it, it just makes me stop and go again. How did he jump to murder-suicide on this? Anyways, let's keep going.
State police, because they have greater resources. So they bring the crime lab down. It's a guy named Talbot, Detective Talbot, professional, a very seasoned professional. You fill out a report. Might have body camera video, not in this particular instance, but you get a form, and it's just a form. It says Idaho State Police, date of investigation, address of investigation, and then it's like a spreadsheet, and you just fill it in. So you say number 1, 2nd floor bedroom, blank coffee cup, whatever, and then you bag the item and you put it in evidence.
Cataloging the whole.
Page 2,
there
item
you go,
number 14, K-bar Marine Corps style knife sheath found, next box, found on floor next to victim number 3.
Next to the girl.
The girl. And it's not
on the floor. And look, I remember, it's so funny. This takes me back. I remember having a mental fight about this before I knew it was going to be a fight. I said, wait a minute. The document says it was on the floor. Other people saying it was found underneath Maddie. So is the answer, I remember saying this, is the answer it was underneath Maddie on the floor? Because when I heard underneath Maddie, it made me believe it was tucked under Maddie's body some way, under her leg, which is indeed what they said it was, because they got a photo of that kind of positioning of it. But then I was like, well, wait a minute. I see the document says it was on the floor. So did we misunderstand it? And under Maddie meant under Maddie, but on the floor, under the bed on the floor?
I'm going to throw a couple of monkey wrenches in here.
Yeah.
Okay, on the specific thing. When Moscow Police Department a year ago released, the only time they've done it on their website, released, or the city of Moscow's website, released the documents from the MPD, one of the first things I looked for was the first 5 responders' reports. Nunez, Warner, Gunderson, Snyder, Smith. Not one of them mentions a sheath. Not one. okay, this is an area where knives are pretty popular. You know, you got hunters, you got, you know, people that have them, they throw them and they have axes and everything.
Mm-hmm.
Yeah.
Well, okay, you're saying 1, 2, 3, 4, 5 missed the sheath under Madison.
Right.
Warner got so close to her body, he's talking about lividity on her leg.
Yeah.
You know, Snyder's going in there, and this is not a large room. He's getting up close and personal. I would think that there would have been, even though we haven't seen the Snyder photographs, which you see him going in the room at 12:29 or so. They're at the door. Those, I want to see the body cams from those first 5, and I want to see the Hunter, the Snyder photos. They can redact everything they need to do. Just show us where the sheath was.
By the
Show us
way,
where the sheath was.
I like to do education on this channel a little bit, and sometimes I forget not everybody knows some terms that we all know and use all the time. And if you're near true crime, you probably do know it, but I want to point something out, because one of the questions we had early on was, how did the officers arriving on scene determine that nobody needed help? How did they know they were already gone? And lividity is probably the answer to that question. So lividity is the pooling of blood in the body after your heart stops pumping and you've been sitting there for a while, laying there in that position. Your blood tends to pool down towards the lowest point of gravity on the body. And so you get this dark purplish color. And so if the officers were trained and saw bodies laying there and the lividity signs of dark blood pooled down below, they could already determine these people are beyond being saved. They've been dead for a while. So at first I was like, well, how did they determine? How did these guys determine already that the paramedics shouldn't come in? There's no need. Lividity may be the answer if they saw clear signs of lividity and knew that the bodies had been there for a while.
You know, and then the other point that I wanted to throw out, if I could, is that page 1 of the PCA, paragraph 1, paragraph 2, states that Detective Brett Payne and Sergeant Blacker arrived at 1122 King Road at approximately 4, and Payne was taken through the house by Smith. Now, Smith's report, he starts writing it a couple minutes after 4. Usually, cops will write their reports at end of shift.
Yeah.
But in any event, there, and he concludes somewhere around 4:20. This is PM on the 13th. He wrote, I think his report's number 1. He doesn't mention anything about taking Payne through. There is no body cam that's ever been released. So I'm of the opinion that Payne was there one time with Smith, and then at 5 o'clock, after the aforementioned warrant was issued, after he gets the warrant, then there's the group of 5 who go through, and it is Blacker. It's the 5. It's Thompson. It's Jennings. It's Talbot, and it is Payne. So,
and the timing of that could be absolutely critical of when the knife sheath was discovered and who found it.
Well, hey, and there's a discrepancy there, because if you ask Chief Dallinger, he says that Payne found the sheath. Blacker says it was the ISP who found the sheath. We don't even have agreement on who. And then you get Talbot in his report saying the sheath was found to the left of Maddie. Payne says it was to the right. Then we got this other documentation that we haven't seen
on
Mr.
the floor,
Wickham's talking about, that it's on the floor. I could see it being on the floor. And then he says at one point when you interviewed him, this is why I went back and I did my 3 Days in Moscow series on the chain of custody of the sheath. He had said, you know, they took pictures. ISP took photographs of the sheath on the bed after the girls were removed in the blankets. How didn't that, unless that sheath was glued, how did it fall down? How did it go back up onto the bed again? Who moved it? Did it jump back up there? What happened?
Right. And Turvey, just to finish the knife sheath discussion, Turvey said it was clear that the knife sheath was put in after the blood had dried, because there's no smearing of blood. And so his conclusion was that it was likely on the floor for some time. The blood had dried, the mist had dried, and then it was picked up and placed, shoved underneath her leg, but no smearing because it wasn't wet anymore, which indicates that it was somewhere else.
It was in pristine condition. I think I remember A.R. Hayes or something said at one time way back, he said, I've seen sheaths hanging in Walmart that were in better, you know, that this was in better condition than that. It was like in pristine condition under her body. And I think that that's the reason why. That just to me seems the most logical reason why 5 first responders and then Snyder going back and taking photos didn't mention the sheath because it was on the floor.
Because it
and
wasn't
right.
Wasn't
That's my
easily
opinion.
it wasn't easily visible. It was probably under the floor and probably a little bit kicked in so that you didn't immediately see it with the eyeballs. That's what I'm thinking. That the
Oh,
knife
me
sheath was
too.
on the floor and under the bed enough that it wasn't easily seen from somebody walking into the room.
Right, like it wasn't in the middle of the floor. It would have
And
fallen
look,
off. Maybe when when whoever it is over her. If it's even the intruder's sheath and not her own, like some people have said, well, maybe they had that for their own protection. Who knows?
I forgot who it was, but somebody, even one of the experts or whatever, or I can't remember who it was, even kind of gave their explanation of why it would be not too much of a big deal that the knife sheath was on the floor and under her leg. And here's the explanation. Maybe the officer who first moved the sheet, it bumped the knife sheath from under her leg. It fell on the floor. They recorded that it was on the floor, but then put it back where it was originally at when they moved the sheet. So therefore, that's their answer. If it does come out that it was ever on the floor and also under her leg, the answer is someone probably bumped it, went, oh shit. They made a quick note that it got onto the floor and then put it back where they found it. And that's their answer for why it had been moved.
Interesting.
But I'm not
one of the
buying that.
mysteries, one of the big mysteries of the case. One of the big
All right,
mysteries.
let's finish this interview.
A typo where he said found on the 3rd floor next to the victim. It says found on the floor next to victim number 3. In the very next line, it identifies her again as victim number 3. So there are some anomalies, and you would look at this and say, now, wait a minute. Are we going to take police at their word and say that we're going to believe you? And the answer is yes. So should we believe him when he say he found the knife sheath on the floor? One might argue yes.
Yeah.
Then why in all the photographs and why in the analysis is it found in the bed under her thigh? So there are so many anomalies like this. And then there are chain of custody issues. The biggest one is this. Ann Taylor, in trying to defend her client, would go to Judge Hippler and file motions. I'm not a lawyer, but it's pretty common knowledge. Some of them called motions in limine, and there is a thing called a Franks hearing. Franks is not Frank apostrophe S. It's a guy named Franks, like the Brady disclosure, which is Supreme Court law that says that if a witness is deemed to be corrupted in some manner, they lie in a case, they're found to commit fraud in a case, whatever, they will always be identified as a Franks exclusion. They can still testify, but they have to announce that they've somehow jaded, right?
Yeah.
So there was a Franks hearing asked for before Judge Hippler by Ann Taylor, the defense attorney, and she came in, lead investigator of the case.
Did he get that wrong? The Franks hearing and the Brady hearing, because it sounds like he's talking about Brady violations.
I think he's talking about Brady, but Franks is Franks for Jerome Franks versus Delaware. That has to do when you're attacking the warrant affidavit. Brady is basically a dirty cop, and
I think he conflated the two, because I think the Brady violation and disclosing that you have a Brady violation is what he's talking about, but he called it a Franks, and the Franks hearing is different. So I think he kind of messed that up, but personally, all right, let's keep going.
In the case, asked him if the FBI ever told him that Brian Koberger's DNA was found on the knife sheath, and he said, no. One word, no. Period. Everybody
who said this? Lee, who said that?
Payne. Let's go back. Let me go back again.
Wow.
Here we go. I'm gonna play it again.
One word, no.
Let me go back a little bit.
Came in, lead investigator of the case, asked for before Judge Hippler by Ann Taylor, the defense attorney, and she came in, lead investigator of the case, asked him if the FBI ever told him that Brian Koberger's DNA was found on the knife sheath, and he said, no. One word, no, period.
Yeah, that was in a
Everybody who knows
hearing.
anything about this case thinks that Brian Koberger's DNA was found on a knife sheath. So then the question is, well, wait a minute. What do you mean the FBI never told you that? She said, what did the FBI tell you? And he said that we should treat this with no more credibility than a tip.
Oh, great.
I can't remember if he said anonymous tip, but they said a tip. So then you go back and you say, well, wait. How is this conceivable that the evidence is a white car?
Millions of those, yeah.
Cell tower,
Not
maybe
great.
more than not great.
Yeah.
And now you've got the DNA. And you have in a court hearing before the judge, the lead detective in the case saying the FBI never told him the DNA was on the knife, Brian Koberger's DNA was on the knife sheath, and that it was sufficient only to the point where it should be given the weight of a tip.
And they themselves didn't have their own DNA lab to send it to. So they were reliant on the FBI.
Great question. The Idaho State Police do have a crime lab.
Okay.
The sample was sent, the knife sheath was sent to the crime lab. They sent a DNA sample to a crime lab in Texas, Woodlands, Texas, called Othram Labs. It was a private lab. So the state of Idaho didn't want to build a lab themselves.
Yeah.
So they contracted to a private laboratory. They took the evidence to that laboratory and they gave the evidence to the laboratory. In the Franks hearing, now this is not me, I'm just reciting what's in the Franks hearing. She, Ann Taylor, the defense attorney, asked them about the DNA and said, where are the reports? The whole point was, you say that his DNA was found on the crime scene. Where's the reports?
Yeah.
And they said, there are no reports. And she said, what are you talking about? They said that they identified the DNA sample on the knife from the knife sheath and tied it to one of 4 brothers. And she said, who are these brothers? And he said, I don't know. I don't have the name. Why not? Because there's no report. Where's the report? I don't know.
It's been lost
through this whole thing.
It's been lost. The official
Look at her reaction.
The official documents of who the 4 brothers were isn't even around anymore. We lost that paperwork.
Oh,
So
that's not important. That's not
trust
important.
us, bro. It does eventually leave. If you go from the 4 brothers, it gets to Koberger, but we don't have the 4 brothers anymore. We don't have that data. It's been lost. Oops, sorry. Trust us, bro. It ended up at Koberger.
But the salient feature, to come back to your question, is, and it's a great question, is were any of those brothers named Koberger? And the answer was no.
Right.
Right.
So yeah, it's just a tip. No, we can't show you any of the DNA evidence because we don't intend to use it at trial. And yet I still, to this day, get people saying, you're an idiot, DA. They were totally going to present Brian Koberger's DNA at trial. It was all over. And Cy Ray is going on national TV now saying, yeah, Koberger's DNA is all over that knife sheath. They were never going to show it at trial. They told Ann Taylor they never intended to show it at trial. It couldn't be used at trial. It was obtained by IGG, which is inadmissible in court systems. And they knew that. But yet we still have people saying Koberger's DNA was all over that knife sheath and they had him dead to rights.
See, I wish that, these talking heads that get these people that don't know anything about this case that are going out and they're telling people and millions at a shot. I wish that Wickham would explain it just as he did there. He explained it to me like I'm a 6-year-old, and I know this, but I need to be refreshed on it. And he's got access to information we don't have. So what do you think, Lee? I'm going to ask you a question. What do you think? He's saying that there's up to 12 alternative perpetrators. That's scary, man. I would think there were that many. But what do you think Wickham won't say if he believes Koberger? Anyway, it's up to a jury anyway, legally. But he won't say. What do you think? Do you think he said he feels he was involved somehow, accessory before the fact, after the fact, co-conspirator, alternative perpetrator, or just not at all?
I have to be careful because I don't want to ever betray something that Wickham said to me in privacy. So I'm trying to remember what he said publicly. But
publicly, yeah. Like he won't,
I know, but
say.
What I'm trying to say is this: his reaction to Koberger's guilt was very, very telling to me. Right. So this is going to be my interpretation of Christopher Wickham's reaction. His reaction was essentially, fuck him. If Brian Koberger wants to spend the rest of his life in jail, then that's on him. I don't think Wickham believes Koberger did it, but he pled guilty, and there's an anger in his part. He's like, well, fine. If he wants to say he did it and he wants to go down for something he didn't do, then fuck him. That's his choice. He's almost angry, like it didn't happen, but if he wants to say it, then that's on him. And so there's an anger, it feels like. With Christopher, it's an anger like, I'm not going to argue against the guy that wants to say he did it. If he wants to say he did it, then what am I supposed to do? I'm not going to fight for a guy that's not going to fight for himself. That was kind of the attitude I had with it. So I don't know that he believes he's guilty. It's more like, if you're not going to fight for yourself, dude, then I'm not going to fight for you either. So, you know.
Right. It's like, okay, so I love the people. This girl right here, she knew nothing about the case, very, very little. So within just a few minutes, Christopher Wickham has educated her that the suspect vehicle 1 is BS, that the phone pings is BS, and that the sheath, the absolute central part of the case, whether it was
the primary part of the investigation. Yeah.
So where's the evidence beyond a reason? Where's the evidence even to a preponderance standard? That's the civil standard. Where is it?
Yeah.
Much less beyond a reasonable doubt in this capital case. And people are saying, oh no, he's doomed. He's not.
You made a really great point right there. Just much like in the O.J. Simpson case, which is, I know, old for a lot of people. People weren't even born. Some of the people watch this probably weren't even born when that case happened. But O.J. Simpson was found not guilty of the criminal case and guilty of the civil case because of what you just said. There's a difference between the guilt beyond a reasonable doubt and just preponderance of evidence. The civil case has a lesser standard, which is just preponderance. And I think that Kohberger likely would win a criminal case because there is reasonable doubt, and any jury would see, in my opinion, despite the fact that Cy says 10 out of 10 juries would have convicted Kohberger, I say bullshit. He had a reasonable doubt for days, and had they been allowed to say all the people who had better motives than Kohberger, reasonable doubt would have been in their minds for days. But again, then he could have then faced a civil trial, and that's just preponderance of evidence. And they probably would have been able to convince a jury in a civil trial that the majority of the evidence kind of leans that way, and we don't have to have beyond reasonable doubt, just as long as we're reasonably certain you probably did. And that's the standard in the civil case. And so he probably could have lost a civil case.
But I mean, who was it? Sergeant Friday had mentioned that maybe he thought he was getting an Alford plea. Yeah. And he's up there and having to, we're not going to know until we see this next round of information here. But I think, for a year, I've been racking my brain just like a lot of other people, just trying to look through the documents, if anything could lead me to understand why at the last minute he changed to, he didn't even enter a plea. He just stood silent to now he stands up in open court. Maybe he thought he was pleading, an Alford plea. Hey, I realize that the evidence is, and just didn't understand that portion of it.
Here's an interesting question from you from a legal standpoint, Kathy. I don't know if you can walk me through the answer to this. You know how in cases like a spouse is not required to testify against their spouse. They can basically say, I plead the fifth. I'm not gonna testify against my loved one or whatever. Same kind of thing probably applies to the family, where his mother, for example, doesn't have to testify in a case against her own son, kind of thing. But here's the wrinkle. If Brian Kohberger's ace in the hole is, you told me certain things and my family was present when you heard it, does that mean that if the family decides to testify that did happen, that they're now open to be questioned about everything they knew? Like, is it an all or nothing thing? You either remain silent and you're not going to testify, but you don't get to pick and choose what part you're going to testify about. So could Mary Ann Kohberger want to testify that, I was there when Ann Taylor told him, take the plea deal, it's just a formality, it's better for you and we'll fight this later, and they lied. But in order to say that, she then puts herself on the stand to be questioned about, did your son ever call and admit guilt in any shape or form? Did your husband ever? Can they ask them questions that they wouldn't normally have been able to ask because they couldn't put them on the stand?
Well, I don't know about Idaho, but I don't know of a parent-child privilege, with a grown child. There's a spousal privilege, like you say, and that's right.
I don't know. You're right. I don't know. Is there a parental? Does it count for parents, or is it just for spouses?
Yeah, I think it's more. I don't know. Maybe there might be one in Idaho. I'm not aware of it. It's more like, and that's why you see the movies. Hey, hurry up! Let's get downtown. Let's get married. This way, you can't testify against me.
Right.
That also goes to attorney-client, like which is just confounding me regarding this Cy Ray, because he's bound, even though he's not an attorney, he was brought in by Mr. Kohberger's attorney to be an expert witness. And there's a very good reason why there is an attorney-client privilege, because the law wants people to speak openly, unless they're going to tell them, hey, I'm going to commit a crime, tonight. then, there's situations where that can be broken. But for the most part, if they're telling you stuff from the past, you want people to be able to speak open. So I don't understand this Cy Ray situation, number one. And I think that they're already sort of now implicated because he's put their names in his pro se paperwork.
Yeah.
So yeah, I mean, possibly we could see the state calling them on the stand now.
Yeah.
What did you, and then, I mean, if they get into other things, this is really it's not a direct appeal. This is just looking at what happened at the time of sentencing, entering into the plea deal, not everything from the beginning of the case. So
how does it work? Kathy, do you know how it works? I believe Hunter Johnson and Emily got married.
Right.
Is that and also, of course, the Steve Gonzalez Jr. got married to Olivia from
the true
YouTube
crime,
thing.
girl,
Right,
and they're
right.
turning around, attacking.
So,
I mean, like, she's a true.
So how
crime
does it
person.
work? How does it work if there were a trial and Emily, for example, is brought on the stand about things that she may or may not know, and Hunter's brought on the stand about things he or she may not know, but now they're married and don't have to testify against each other. So then how does that work if they're like, can Emily speak on behalf of what Hunter did, or can she only say, like, that makes a weird situation. People have brought this up before. Well, isn't it convenient that Emily and Hunter are married now so they don't have to testify against each other if it goes to trial? But I'm thinking, well, can't they still testify individually? Maybe Emily can't tell you what Hunter did or said, but she could tell you what she did or said. I don't know. It makes a weird scenario.
Well, she owns the privilege. Let's just say that there's, like, remember that, who was that couple up in Canada? They called them the Barbie, the Ken and Barbie, that they went out.
Yeah.
Remember, they attacked those young girls and everything, and then he beat her up, and she testified against him. She decided to decline. Like, Kohberger owns the attorney-client privilege, and Ann Taylor can't break it. Yes, she can defend herself, to what she needs to do. But Kohberger still could say, hey, you keep your mouth shut, regarding what we spoke about.
Someone told me that at the moment Kohberger said ineffective assistance of counsel, that she's no longer bound by attorney-client, but she can now say whatever she wants because he essentially negates the client-attorney privilege by calling her out and saying she was ineffective. And I don't know what the rules are on that.
I don't know. That's a good question. Like, how far does it go? I mean, is it now open field? Like, she could go back to the first meeting that she had with him back in December of 2022.
Yeah, and say, hey, by the way, he told me
game?
he was flat out guilty in the day one. Yeah.
Right. Or is it limited to just defending herself regarding this is post-conviction relief? And we got to keep reminding ourselves that what's on the table right now it's not a general appeal. It's not everything. It's not going to be chain of custody of the sheets. It's going to be what was it that happened that got him to change his plea, and what, if it didn't happen, he wouldn't have changed his plea. And I say change his plea. He never pled to begin with because she stood silent. But what convinced him? And that's if he can turn around and say, hey, I wouldn't have pled guilty if I knew that there was all this discovery that we hadn't looked at. If I knew that there was this exculpatory evidence, and he gave a couple of examples, who knows how much more there possibly is.
Yeah, and I mean, I may be biased, but I think he's got a good argument. He maintained, even Bill Thompson said, we were surprised by the plea because for 3 years now, Brian Kohberger has maintained his factual innocence, has always maintained his factual innocence. What happened in the week before they seated jury that he suddenly flipped and says, that's it, I plead? And of course, mainstream media wants you to believe it's because he realized he was fucked and at the last minute because of something new that came out. He realized he was fucked and then threw in the towel. But is it that, or was he lied to and misled about something a week before they seated the jury, and then he decided that this was the best option because he thought he had no chance, but he was misled?
And there's two other, I think what shocked people so much about this plea deal is because you had Eliza Massoff and you had Ann Taylor stand up in open court and proclaim that he was factually innocent. Defense attorneys don't do that. They will say that there is an absence of, evidence beyond a reasonable doubt. They're not going to vouch for their clients. They're not there. So that's another piece of the puzzle. And you're right. They were Friday before this plea deal. they're filing additional, not their original, but additional, information regarding jury instructions. It looked like they were going to jury trial. And then all of a sudden, and the two biggest theories that people have had, he was worried about the DP. Well, he's saying right now, bring the DP on, I'll welcome it. And the other thing is he's afraid that his parents were going to get involved and have to testify. He's got all 4 family members now that are
they're ready, and they're essentially ready to testify. Yeah. Well, here's the thing. We need to wrap up now. Robin's needing to do something, and I also have something that's coming up for me as an obligation as well. So sorry to cut it kind of brief, but it's been a great discussion. I'm glad you came up, Kathy, and joined us for this legal discussion. And thank you for all of you who, I really, really want to say, I love the fact that there was a bunch of other streamers all streaming the same thing, but you chose us today. So thank you so much for choosing us as your place to watch that streaming coverage. It means a lot to us that you chose us today as your channel of choice. That it's not to say anything negative about any of the other streamers, but of course it means a lot to us that you picked us. And thank you, Kathy and Robin, for joining me today for this discussion. And well, maybe we'll see you tonight on the Crimes After Dark show at 5 p.m. Pacific Standard Time. Take it easy.
Bye, everybody. Thank you.
Take care, guys.